Good morning, everybody. Sorry for the late start. My associates were having trouble getting me in, but I'm now in by the looks of it. And I'd just like to start off with a slight change of plan. One of the participants, Nishan Paramjorti, can't make it today. So we've had to rearrange the timetable a bit. Basically, each of the remaining speakers will get longer to speak. And that actually means that we'll have longer to deal with questions which arise in the course of our talks. So if there's anything that you'd like us to talk about at the end of each talk, just type your query into the chat box or the question and answer box, and then we'll have actually longer at the end of each talk to deal with those queries. So the first talk today is actually by me, and it's on the appeal process. So I'll see if I can get on to, this is the first time I've done it, if I can bring up some slides for you. I've never done that before, so I hope I can remember how it's done now. Well, hopefully you can see that now, folks. This is the introductory slide telling you what it is. And then we're going to go through, in a rather disjointed fashion, various aspects of the appeal process, not going from start to finish, as it were, in the proper sequence, but just picking out some of the issues that can arise in the course of an appeal. And in fact, I've started off with something that comes towards the end rather than at the beginning, and that is the respondent's review. Now, that's something which the Home Office is supposed to do in response to the appellant's bundle and the appeal skeleton argument, which are provided by the appellant after receiving the respondent's bundle, notice of appeal having been given. So this is supposed to be the respondent's review. This is supposed to be received by the appellant, or of course the appellant's representatives, within 14 days of the appellant's bundle and skeleton being served on the respondent. But it rarely comes that quickly. In fact, I'd like to quote from something that came up at a recent meeting of the Courts and Tribunals Working Group at ILPA, the Immigration Law Practitioners Association. So this was the opinion voiced by one of the leading lights of that working group. And he says, "It seems to me that the review stage is now a pointless step due to the poor quality of the review. It wouldn't really matter if there were no adverse consequences for the appellant. But I have seen a number of cases now where the first-tier tribunal will not list an appeal until the review is done, and the Home Office taking up to 6 months or more to do them, and then producing a worthless document. Whereas the Home Office is getting extensions for serving their review very easily." Well, there's a very critical view of the respondent's review. It can take a long time after the appellant's documents have been served before the respondent's review is received, and sometimes it doesn't even come at all. But is it fair to say that it's largely a useless document? Well, it should comply with the practice direction issued by the Senior President of Tribunals on the 13th of May, 2022, and also with the practice statement issued by the then president of the Immigration and Asylum Chamber of the First Tier Tribunal, also in May 2022. The president then was Judge Clements. He's been succeeded now by Judge Plimmer, and she's working on a replacement for the practice direction, which has been in force since May last year. Sorry, May 22. And that insists, that practice direction and the statement as well, insist that the respondent's review should be meaningful, and it shouldn't rely on standard or pro forma paragraphs. It shouldn't just rubber stamp the reasons for refusal letter, but it should make a meaningful contribution to help the tribunal to understand what the real issues are in the appeal and to narrow down the scope of argument at the hearing itself. So it's to concentrate minds, really, and that hasn't always been happening with the respondent's review. One of the standard or pro forma features in the respondent's review is the case law, which gets shoved in at the end. And some of it can be very long and perhaps not particularly relevant to the issues in the appeal. So to give you an example of that, one of the cases that frequently gets cited is called Mustafa. It's 2015, as you can see, and the quotation taken from that case comes towards the end of the upper tribunal's determination, and it runs, "It will only be in very unusual circumstances that a person other than a close relative will be able to show that the refusal of entry clearance comes within the scope of Article 8.1. In practical terms, this is likely to be limited to cases where the relationship is that of husband and wife, or other close life partners, or a parent and minor child." So is it really the case that Article 8 is limited to just those family members? Well, what the upper tribunal was dealing with there was actually an appeal against the refusal of a family visit visa. Now, family visit visas could be appealed, the refusal of them could be appealed until June 2013. Then that right of appeal was abolished. So Mustafa was dealing with the legacy appeals, which had been launched before the abolition of the right of appeal. But of course, that isn't relevant to ordinary cases under Article 8 nowadays, which are not about family visits. Anyway, what we are now seeing with respondents' reviews is that it's not standard or pro forma, but it actually is a meaningful contribution to narrowing the issues in the appeal and assisting the tribunal to understand what is really in dispute. In other words, what you're getting in the respondent's review is further and better reasons for the refusal. So what do you do when you're landed with a respondent's review, which not only argues rather better than the refusal letter did on the reasons for refusing the application, but even introduces better reasons for refusing, which are not in the original refusal letter? Well, very often it's necessary to reply to the respondent's review. In other words, you have to review the review. And it even comes in the form of a direction from the tribunal. You'll get an email saying you have a new direction, and you're invited to respond to the respondent's review. Now, it's not actually a compulsory direction, although the word direction is used. It's really an invitation that you may wish to reply to this review with your own counter argument. At any rate, if this is what's going to happen, it is an extra stage in the process from giving notice of appeal to the hearing itself. And the reply to the respondent's review would normally be left to counsel to draft. And the solicitor is probably going to be lumbered with extra costs. The barrister is probably going to provide a fee note for his trouble in drafting the reply. So this, of course, lands up ultimately with the client himself, who has to fork out. So this extra stage is more costly for the appellant. Now, there is, in draft, a proposed practice direction of the Immigration and Asylum Chamber of the First Tier Tribunal, and it will be coming out in the name of Sir Keith Lindblom, the Senior President of Tribunals. But it's still in draft. The draft has been distributed among the members of ILPA, but they've been asked not to pass it on outside ILPA itself. So I'm not going to be talking about this new practice direction today. It definitely would be worth a talk at the next webinar, if indeed it's finished by then, as it ought to be. But at any rate, looking at the new practice direction, it doesn't mention anything about an extra stage after the respondent's review, and indeed that's not in the current practice direction and statement either, but it's kind of crept in anyway. One other thing that the proposed new practice direction makes clear is that there's no mention of a counter schedule for the respondent's review. Now, so far, the respondent's review, having started off with a preamble and then listed the schedule of issues, which is usually taken from the appeal skeleton argument. So that simply repeats the schedule of issues that was in the appeal skeleton argument. This is followed by what the Home Office calls a counter schedule, which consists of basically the arguments against what is stated in the skeleton argument. But that's not really what a counter schedule ought to be. A counter schedule ought to be the Home Office view of what the issues are, if they differ from the appellant's view of what the disputed issues are. So, in fact, the Home Office is now being told to provide a correct list of the disputed issues in the appeal if they don't accept the issues from the appeal skeleton argument. So we won't be seeing the term counter schedule in future. Okay, well, that's the start, and I'm going to go on next to the very end of the process, which is the hearing. And it's sometimes complained after the hearing that the judge conducted the hearing unfairly. And one thing that he might have done was to pose too many questions of his own for the appellant, or indeed other witnesses, when giving their evidence. And I'm going to talk about a recent case at the Court of Appeal called Hussein, where, in fact, the judge conducted the hearing unfairly. And one thing that he might have done was to pose too many questions of his own for the appellant, or indeed other witnesses, when giving their evidence. And I'm going to talk about a recent case at the Court of Appeal called Hussein, a complaint was made afterwards in seeking permission to appeal from the first tier decision that the judge had departed from her supervisory role and had descended into the arena, a gladiatorial metaphor, by asking too many questions and asking them in an aggressive manner. So, was in fact the judge trespassing upon what should be left to the representatives in putting questions to the witnesses? Now, those of you who are old enough may remember the Surendran guidelines, which came out in the late 1990s and are set out at the end of a starred tribunal decision. And this is the old Immigration Appeal Tribunal, a starred decision of that tribunal issued in the year 2000. And this was at a time when the accepted view of the adjudicator's role, they hadn't yet become judges, the adjudicator was supposed to kind of be an impartial umpire, sitting back and letting the two sides debate their particular advance their particular arguments. So the procedure was adversarial. The judge kind of holds the ring for the two sides to knock each other about, but doesn't intervene very much. And that's contrasted with inquisitorial systems like they have on the continent of Europe. And one of the metaphors, another of the metaphors used in the Surendran guidelines, is that adjudicators must not appear to be assuming the presenting officer's mantle. So was the judge in this case at the first tier tribunal assuming the mantle of the hoppo by asking too many questions? Well, the issue was a not uncommon one to do with the TOEIC ETS scandal of a few years ago about people taking the English language test by using a proxy, which is using deception if you subsequently rely on that certificate of the English language for applying for leave or further leave. Now, this is what the Court of Appeal said when the case came before them. It is clear that the first-tier judge asked a significant amount of questions, and also that on occasion her questioning was persistent. For example, when she said, I do need to have an answer to this. However, although the number of questions might well be unusual, it is necessary to look at what happened qualitatively as well as quantitatively. There is nothing to suggest that her questioning could be described overall as hostile. Okay, so the amount and persistence of the questions did not amount to the judge conducting the hearing unfairly. So the appeal was dismissed. But there is something which was remarked upon by Lord Justice Moylan. And I think this resonates with what the Lady Chief Justice said quite recently about the duty of counsel to raise concerns during the course of a hearing about the fairness of that hearing, not to be afraid to challenge the judge if the representative thinks that the judge is not conducting a fair hearing. It may not be that easy to intervene when the judge is likely to give you a rollicking. But still, that's what the Lady Chief Justice wants representatives to do, rather than leaving it till after the hearing and then complaining about what the judge did. So here's what Lord Justice Moylan says. Counsel in general have a duty to raise concerns about the fairness of the hearing during the course of a hearing. The absence of any such concern being raised might well be a material factor if it is subsequently asserted that the judge's conduct was inappropriate. So don't leave it until the hearing is done and dusted, because it might be thought that the judge's conduct was not so bad after all if counsel didn't intervene at all during the hearing. Now, I'll finish this slide with another recent case in which the judge really did conduct the hearing unfairly by the way that he put questions to the witness. Now, the only witness was the appellant at the first tier tribunal, and he was said to have contracted a marriage of convenience with an EEA citizen. As usually happens, after the couple had got married, they were invited to interview by the Home Office, and each spouse was questioned separately, and then inconsistencies were found in their answers to the same question. This often happens, and the Home Office will invariably find that the marriage is one of convenience because the couple don't know things about each other that they should, or what they had been doing together that they ought to know. Now, the judge was very cross to find that the wife would not be giving evidence at all, and the only witness was going to be the husband. And he put it to the appellant's representative, Mr. Hussain, that this was not a good idea, and if Mr. Hussain thought that he was getting one over on the judge, he had another thing coming. So there was not a very good atmosphere between the judge and the appellant's representative. Now, actually, it's not clear from reading the Court of Appeal decision that it was actually the strategy of Mr. Hussain not to call the appellant's wife. It could be that she herself didn't want to come before the tribunal and insisted that she wouldn't do it. But anyway, there it is. And the judge went on to put lots of questions after examination in chief and cross-examination had been completed. The judge went on to ask a whole series of other questions, raising issues which had not been raised either in the original refusal letter or in the respondent's review, or even in the course of examination in chief or cross-examination. So he was putting things to the appellant which had not been put before. And he even indicated that he did not feel himself bound by a previous appeal in which the judge on that occasion, which was some years before, had found that the couple were genuinely married. So he was going behind a previous immigration judge's decision. Well, just to dwell briefly on that, well, you're not supposed to, a judge is not supposed to depart from the decision of a previous judge on the same issue, unless there is evidence now before the present judge that was not before the previous judge and which undermines the finding made by the previous judge. Well, the leading judgment in the case of Hema was made by Lord Justice William Davis. That's quite a long judgment, but it would be worth citing a much briefer postscript to the Court of Appeal's decision, which is contributed by my favorite Court of Appeal judge, the vice president of the Civil Division, Lord Justice Underhill. And he says, the hearing by the first-tier tribunal was unfair for essentially 3 reasons, though they are to some extent related. First, the judge asked the appellant a series of questions which went well beyond an attempt to seek clarification and amounted to cross-examination on points not raised by the Secretary of State. Second, he based his conclusions in part on a point which had not been raised with the appellant or his representative, and which was contrary to the finding of the first-tier tribunal in an earlier case. So that's the Devasilan point that I just mentioned. Third, his criticisms of Mr. Hussain not only were unfounded, but were expressed in inappropriate language, which evinced, to put it no higher, serious irritation and some personal animus. I do not doubt that this experienced judge was making a conscientious effort to get to the bottom of the issues as he saw them, but that involved him in descending into the arena. Now, Lord Justice Underhill continues, I would not want our decision to be understood as discouraging first-tier judges from asking their own questions of witnesses, where that is necessary in order to enable them fully to understand the facts and the issues. It may more often be appropriate for judges to intervene during the evidence in an immigration appeal than it is in typical high court litigation. But what is appropriate depends on the circumstances of the case, and the judge should in any event do nothing that compromises the fairness of the proceedings or gives an impression of partiality. We need not express any view about whether it was sensible for Mr. Hussain to adopt the approach that he did, to whether to call evidence supporting the appellant's own evidence that the marriage was genuine. He had evidently thought carefully about it, and we do not know the full circumstances. So here the court is taking the view that it was a deliberate decision by the appellant's representative not to call the wife. But unless an advocate can be confident that the evidential burden will not shift to their client to prove the genuineness of the marriage, they will generally be well advised to call any cogent supporting evidence that may be available. Well, that must be right. I was very surprised to learn that, in fact, the wife hadn't been called to give evidence on the genuineness of the marriage. So that was definitely, if it was the representative who made that decision, it clearly wasn't a good one. Now let's move on to the next slide. And here we come to the question which sometimes is put in submissions or in a skeleton argument about the appellant's case being improved if, despite not being able to fulfill all the requirements of the immigration rules, he nevertheless nearly made it. He just fell slightly short of fulfilling all the requirements of the rules. Now, that has generally been frowned upon by the courts. There was something, I think, in the dim and distant past when Mr. Justice Ousley talked about a penumbra surrounding the immigration rules, in which some advocates would say, look, our client comes as near as damn it to meeting the requirements, so you should allow the appeal. And the answer to that was, a miss is as good as a mile. So if you fall short of the requirements of the immigration rules, tough. Doesn't matter if you nearly get there or if you're far away from it, you still don't get there. So there was a case called Mia and others, which is a leading case on this near-miss phenomenon. Well, it's 12 years ago, Mia and others. And in this, the applicant for indefinite leave was short of 2 months on a 5-year route to settlement. So when he made his application, he was 2 months short of 5 years, and his application was refused because he hadn't clocked up 5 years. Now, the Home Office advises people not to apply for further leave to remain any sooner than 28 days before the expiry of their existing leave. So really what Mr. Mia should have done was to have waited until no more than 28 days before the expiry of his 5-year term, and then the Home Office would have granted indefinite leave. But because he didn't do that, he applied too soon, they were able to refuse him. So that's an example of how strict the Home Office can be, and how it's not a good idea to apply for something when you're short of fulfilling all the requirements. So I was a bit surprised to come across a decision of the Upper Tribunal in 2023, where a presidential panel consisting of Mr. Justice Dove and Mr. Ockleton, then the vice president, and he retired quite recently, in a case called Kagitla. And near the beginning of the decision, which is written by Mr. Ockleton, at paragraph 7, he says, well, when you have a human rights appeal like this one, when, of course, you're not allowing the appeal because the appellant meets the requirements of the immigration rules, but because to remove him would be a breach of Article 8. So it's an Article 8 appeal, but of course the immigration rules have an important role in that human rights appeal. And famously, the senior president of tribunals, then Sir Ernest Ryder, told us that if all the requirements of the immigration rules were met, then that was determinative of an Article 8 appeal, in the case of TZ Pakistan and RG India, 2018. But anyway, having first spoken about that, meeting the requirements of the rules and the appeal being allowed, Mr. Ockleton continues, secondly, an appellant who does not meet the requirements of the rules may be able to show, by relying on the terms of the rules, that it would be disproportionate to exclude an appellant who falls in a very similar category to one who would meet the requirements of the rules. That will not be so if the problem is that the appellant misses, even narrowly misses, a quantitative, that's the way it's spelt, a quantitative, one might say quantitative, or numerical requirement of the rules. But an appellant may be able to show that the public interest demonstrated by the rules ought to be read in exactly the same way in relation to the appellant's own circumstances, despite the latter not precisely meeting the terms of the rules. So this rather gnomic pronouncement by the then Vice President suggests that a near miss might succeed in certain circumstances, but not, of course, if a quantitative or numerical requirement is missed. Now, what was the outcome of this appeal to the upper tribunal from the decision of the first-tier tribunal? Now, what had happened was that the sponsor had come to the UK from the Philippines many years ago as a domestic servant in a private household. And in those days, that was a route that led to indefinite leave after 4 years under Part 5 of the immigration rules, which dealt with employment before the points-based system was introduced in Part 6A of the immigration rules. So we're going back many years. Anyway, the sponsor achieved indefinite leave and then became a British citizen. And at this stage, she invited her husband and her daughter, who was then under the age of 18, to join her for settlement in the United Kingdom. So they started off on a 5-year route to settlement under Appendix FM as partner and child. Everything was hunky-dory. They got their first 2.5 years, and then at the halfway stage, they had to apply for another 2.5 years in order to get indefinite leave. Now, their solicitor at the time must have been very pleased with himself because he was thinking outside the box, and he checked up on the immigration rules, as they still are in Part 5, and found that under Rule 199, it's possible for the child of a person who has indefinite leave and who had leave previously under Part 5 of the immigration rules to join that sponsor for immediate settlement. So you can apply for indefinite leave as the child of someone who now has indefinite leave and previously had leave under Part 5, one of the work routes there at that time. Great, so he thought, let's skip out the next 2.5 years and go for indefinite leave straight away. Now, for some reason, he didn't give the same advice, or the advice wasn't taken in the case of the husband. So he continued along the 5-year route to settlement. But the daughter came to grief when her application was refused. And the reason why she couldn't qualify for indefinite leave was that her sponsor was not a person with indefinite leave to remain, but a British citizen. And British citizenship, once granted, cancels out any leave, any indefinite leave that you already have. The two are incompatible. And that's why, if you're deprived of British citizenship, you don't revert to having indefinite leave. That leave is gone for good. So this might seem a very narrow reason for dismissing the appeal, but that must be why a quantitative or numerical requirement was being missed here. I suppose it was qualitative rather than quantitative, in that British citizenship is qualitatively different from indefinite leave. It's a superior status. funnily enough, the sponsor's partner could actually have applied under a similar rule, paragraph 196D, rather than paragraph 199 of the immigration rules, because that says that the sponsor could either be a person with indefinite leave or a British citizen, provided that she previously had leave under Part 5. So the partner could have done it under that route by the looks of it, but the daughter couldn't. Anyway, that's what happened in the end. I'm happy to say that, in fact, it wasn't quite the end, because the daughter then applied under Article 8, and she won her appeal before a different first-tier judge under Article 8 on the basis that the consequences for her and her parents made the decision to refuse her second application unjustifiably harsh. So she's managed to get onto a 10-year route to settlement now. Okay, well, let's go on down. And the next slide is about overstaying and entry clearance. Now, Chikwamba has often been cited in the past for an argument that if somebody has overstayed in the United Kingdom but has married a British citizen or someone with indefinite leave, and that all the other requirements of the rules have been met, except for not being in the UK unlawfully, it would be unnecessary and really too unfair on the applicant to be required to go back to her own country and apply for entry clearance in order to come back, when in fact she meets all the requirements of the rules, and so she would be bound to be granted entry clearance. Well, in fact, it's a bit of an exaggeration to say that if you're an overstayer, or yes, if you're an overstayer and you meet all the other requirements of the rules, that you're going to get entry clearance inevitably, because there is a discretionary, not mandatory, possibility that you will be refused entry clearance because you have done something during your time in the UK which is sort of flagrantly breaching the immigration rules, stuff like that. It used to be paragraph 320, subparagraph 11 of part 9 of the old part 9 of the immigration rules. Now it's in the new part 9, and I can't remember the paragraph, but you can easily find it. But anyway, the Chikwamba principle has often been relied on, and you'll remember in Chikwamba itself at the House of Lords, a lady who was here unlawfully. She was from Zimbabwe. She'd married a refugee from Zimbabwe, and they had a daughter together, and she was told that she had to go back to Zimbabwe and apply for entry clearance to return to her husband in the UK. And the House of Lords said that it shouldn't be necessary in a situation like that. But Chikwamba was distinguishable in several ways from other cases where the applicant is an overstayer who's married somebody settled in the UK. Anyway, in UNAS, the question was whether the mother, in this case, should have to go back to Pakistan and apply for entry clearance there in order to live with her husband and their British daughter in the UK. Now, what was distinguishable about UNAS in contrast to other cases, I think is quite important, because UNAS, in UNAS, the bugbear was that the current status of the mother was that of visitor. And to switch from the visitor category to any other category under the immigration rules while in the UK is not permitted. And in particular, there is a paragraph in Appendix FM, I think it's eligibility for leave to remain, ELTR, P, whatever it is, which says that it's headed immigration status requirement. And one of the requirements is that you should not be in the UK as a visitor. And if you are, you can't even take advantage of EX.1 and EX.2. There's no avenue, if you're here as a visitor, to rely on section EX, because there are insurmountable obstacles to your continuing family life abroad. Instead, you've got, oh, there it is, ELTRP 0.2.1. That's the immigration status requirement. So Ms. UNAS was in that situation where she was a visitor, and so the upper tribunal concluded that it was reasonable for her to return to Pakistan, even with her young daughter, who was, I think, under 4 years old at the time, who would have to go with her. But the upper tribunal found this was not unreasonable, because the child had not yet started school, and she would be well cared for by her mother, and she wouldn't have to spend more than 9 months in Pakistan waiting for a decision on the entry clearance application. Well, I suppose 9 months would not be an unusually long period of time to wait for a decision on an entry clearance application. It often gets to be longer than 1 year. But anyway, I think UNAS could be distinguished from other cases where the applicant or appellant is not a visitor. And if we look at how the Chikwamba principle should now be applied, according to the Court of Appeal in Alam, the court, if I can find it, the court says something about, I think it's actually in your course notes rather than in the slide itself. So let me just get hold of that quotation from Alam. Yes, this says, the decision in Chikwamba is only potentially relevant on an appeal when an application for leave to remain is refused on the narrow procedural ground that the applicant must leave the UK in order to make an application for entry clearance. Well, my take on that is that the requirement to apply for entry clearance is not or rather the possibility of applying for entry clearance is not the only reason why the application has been refused. And in fact, if there are other reasons given for refusing the application, I think you could argue that Chikwamba is still relevant, in that it shouldn't be necessary for the appellant to apply for entry clearance if she does meet all the requirements of the rules, apart from being in the UK lawfully. And I've already mentioned TZ Pakistan, where all the requirements of the rules are met, including Section EX, that it is positively determinative of an Article 8 appeal. In fact, Section EX is within the immigration rules. It's in Appendix FM, and if an immigration judge finds that it would be there would be insurmountable obstacles to family life being pursued overseas, that in itself is part of the immigration rules and could form part of the conclusion that all the requirements of the rules are met. And we'll end this slide with the comment that rather oddly, if you're here in the UK as an overstayer, you can rely on EX point 1 and 2, but you can't if you're here as a visitor. Well, my next slide is going to be about a new practice direction, which is now in force, and it's from Sir Keith Lindblom, again, the Senior President of Tribunals, and it was issued on the 4th of June, 2024. And what it does is emphasize for both the first tier and for the upper tribunal the necessity of giving adequate reasons for their decision, but not spending too much time about it. So emphasizing the need for concision, but also emphasizing for the upper tribunal not to be too hard on the first tier when deciding that the first tier have made an error of law. Well, I'm going to stop rather short of finishing this slide because even though we've now got more time for each speaker to rabbit on about their particular topic, I do need to finish off quite soon for our next speaker. So let me come to an end here and rejoin the Zoom meeting. If I can just find out how to get out of this. Here we are. I'll get back into the meeting, I hope. Oh, stop sharing. That's the one. Stop sharing. Here I am. As you can see, I'm not used to this at all. It's my very first slideshow. But anyway, let me now see what we've got in the chat box and the Q&A box. So starting with the chat box. Oh, I can't seem to see anything. Oh, this is just from the host. So righto, let's get away from that to the Q&A box. And we've only got 2 questions, so I won't be taking long. One is from Aisha Rashid, and she asks, for indefinite leave to remain, the Home Office has been more strict, as they say that one cannot apply for ILR until the applicant has clocked up their 5-year continuous lawful residence. Recently someone contacted us to appeal the Home Office negative decision for submitting their ILR application 3 days before their 5 years were completed. Oh, well, Aisha, thank you very much for that. I wasn't aware that that you had to complete the 5 years before you even apply for indefinite leave. So if you're right, I'm definitely wrong when I say that you can still apply up to 28 days before you have reached the 5-year point. Now, the other question is from Malik, but apart from his name and hello, I don't actually see the question, so it doesn't appear to have come through. So sorry about that, Malik. We do have an opportunity later this afternoon when there will be a panel discussion for that question to be brought up. So we'll be having our panel discussion from 10 to 3 till 3:30 this afternoon. Oh, and here is just one more question, sorry, from Mr. Mahmood of Council. Mr. Samir Mahmood, please can you quote the source of the criticism, re the poor responses from the Home Office in relation to the review? Well, I mean, this was just at a meeting of the working group. It doesn't represent the considered view of ILPA itself. So it's not something that has been put in to a letter to the Home Office or to the tribunal by ILPA. So it doesn't represent the considered view of ILPA itself. It's just a contribution by one of the members. So I don't really think it's quotable as ILPA policy, if you see what I mean. So, you know, I don't think it would be fair really to name the guilty party who's criticized the tribunal in this way. But I just thought I would throw it in because it's just a view shared by, shall we say, shared by quite a number of people who have to deal with appeals quite regularly. Now, waiting in the wings, we have a lady who has been with us as a speaker for many years. And alas, this is her swan song, because Samina Iqbal, who's been a fee-paid judge of the first-tier tribunal, and would I be right in saying also a deputy judge of the upper tribunal for quite a number of years? This will be the last time that she's able to be a contributor to the webinar because she's been appointed a full-time salaried judge of the first-tier tribunal and presumably also deputy judge of the upper tribunal. And you're not allowed, if you're a full-time judge, to participate in an event like this, which is basically a commercial event. So we shall be very sorry to lose you, Samina, but you're not leaving us quite yet because we have got your contribution coming up next, which is a case law update ranging quite widely. And I'd better let you get started. It's now 25 minutes to 11. So we actually are starting on time under the new timetable, starting from 10:35. And you've got a full hour to give your talk and also to answer any questions that crop up in the Q&A box. So over to you then, Samina.
Thank you. Thank you, Richard. Yeah, I'll be very sorry to leave these webinars. It's been really interesting with lots of interesting questions from all the delegates. But time to move on, but you will still be seeing me around. I'm just going to share for now my screen. Hopefully there is going to be no issues doing that. So if I can... Hopefully you can all see that now. Just move this out of the way. Okay, and today I was going to be talking about or doing a case law update, family and private life claims. When I came to start preparing my webinar, I thought that I'd previously given quite extensive update in relation to family life claims and case law. And I saw a number of cases which focused on private life claims, which I don't think we've really covered before. So I thought I'd take this opportunity to do that. There is going to be some coverage of family life claims, but I'm sure that a lot of you will have questions and find this part of the update in relation to private law claims quite interesting. So what am I going to look at? Let's see. Yeah, sorry. So appendix private life. So that's looking also at private life or asylum claims. I know that this has been touched on by the upper tribunal before in some case law, but I want to look at it in a bit more detail given a recent case. Going to look at private life in returning residence cases, also limbo cases, those in the United Kingdom who are not being granted leave, what happens to them and their private life. We'll touch on the EUSS, of course. We can't leave private life without looking at Article 8 cases and the interaction with EUSS. And then I'm going to look at exceptional circumstances. Again, I say again because back in February, I did deal with this quite extensively, but I think there's something which has come to light, which I think is going to be important just to flag for your cases going forward, given the minimum income rule that has now been introduced and the exceptional circumstances that one can look at when considering such claims or when making such applications for your clients. At this stage, I just want to flag to everyone, of course, that a person who makes a private life claim under Article 8 for, I think there's about 3 reasons, won't have to make it on an application form. So they can make it at the same, a private life claim can be made at the same time you're making your asylum claim. You can put in elements with reference to your private life in your asylum application. And you can raise protection issues. An individual who's in detention, but also in removal cases. Now, in all of this, if it's a new element to either of any of these aspects, sometimes you'll require the consent of the Secretary of State. And I am hopefully you're all quite familiar with how to obtain consent, issuing a Section 120 notice and so on. But I'm not going to cover that today. I just want to flag it for you. You'll also have to excuse me. I do have a cold, so if you see me coughing or sneezing at any point, you'll have to give me a second. I will put myself on mute. Right, so just want to, at this stage, look at the 20-year rule on long residence. It's now in Appendix PL at 7.2, and it makes it's quite self-explanatory. I flagged certain elements of it here, and that is what can break the periods of residence. Here you'll see that it does not include any period of residence where an individual serving a sentence or imprisoned or detained in an institution other than a prison. And it can be broken by, at 7.3, removal, absence of a certain number of days, and where an individual's left the UK without any reasonable explanation. It's always helpful to flag the guidance. So private life guidance here, the current one, I think still survives, which is the 18th of May, 2023. And helpful tips. I think we just forget sometimes when we make these 20-year rule applications, sometimes we're quite lucky where we have a previous determination which records and makes finding a fact about the 20 years and an individual having arrived at a certain time and that being accepted by all parties. But there are also, you also have to be aware of the interim periods where there's interim years. We often see that where an individual can't record or can't provide evidence. So the best, just to flag that don't just rely on a previous finding where that decision, where it's been accepted that that individual entered at that time. It's always best to front load your application. So always ensure, and I would say in the application or in the letter that accompanies an application, always address the suitability grounds, that suitability is being met. And of course, if it isn't, if there's an issue that arises that the respondent raises, they have a duty to raise that in accordance with the guidance that was given in the Balajigari case. So if someone's saying you're not suitable because you acted dishonestly, or there was a road traffic accident, or something that the Secretary of State raises, they have to give the appellant an opportunity to respond to that. So it's a minded to refuse, and they if they haven't done that and you receive a refusal and suitabilities raised, you must then go back to them and flag the Balajigari guidance. Okay, ensure that you're providing documentary evidence, but also witnesses, any witnesses that can attend who might have known an individual during that period. And I know that all of us will have experienced that on many occasions. Witnesses are not are seen perhaps as self-serving, or perhaps not as persuasive in demonstrating that an individual was there for that period of time. But sometimes individuals, witnesses, it's worth questioning them whether there are any photographs for the years that they are relying on when an individual was with them. And you often see those photographs because you can see the change of the individual's appearance. They might have looked younger in those photographs, so you can date, they may well be dated back to a further a period of time which is further back in time, which therefore corroborates the appellant's account. Now, I've already flagged here that it's important to look at continuous residence and whether it's broken by any period or time in prison. And it's I would say that continuous residence seen in these applications, in 20-year applications, is much more flexible than long residence continuous residence. And I just flagged the guidance here because I thought it's just worth reminding ourselves about the flexibility in these applications rather than the 10 years here. What happens if you meet the 20 years and if you, at the outset, you're granted 30 months on a route to settlement over 10 years. So nice short area. This is one of the 5, I think it's 5 under private life that we see that are under Appendix PL that we see as a category of individuals that can demonstrate they have private life. Now, if I go on to the half the life test, I'll just skim over this, but I just want to remind us, because when we make applications, and especially when we've got a young adult, perhaps within the family, so you're looking at various family members and you're looking at a young adult, I think it's always, we should always remind ourselves and look at the young adult in the family circumstances. Just don't look at the parents. Calculate whether or not they might have been here half their life. So I've just put there an example, and that comes directly from the guidance. If you're 24 years old, you're under the age of 25, and between the age of 18 and 25, and at the date of application, you must demonstrate that you arrived in the UK by the age of 12 years and 3 months. It's a simple calculation. It can get confusing depending on what age an individual is and what's the date of application. But if you remember those 3 elements, date of application, half their life, and the time they arrived, then I think making that calculation is easy. And put it in your application. Put it in as a separate element, set head. When you're making these applications, put a separate heading which addresses these issues. I'm not taking you through the 7-year rule for children. I think we've always talked or covered that quite extensively on reasonable grounds. These are the ones I thought were important to cover because they're and we often forget about them, particularly this one. So collate the evidence that you might be able to put together with reference to the date of entry in these kinds of applications. Now, very significant obstacles, again, something everyone here is going to be so familiar, and it's one of the regular elements or one of the regular categories of individuals in the alternative that we put forward if they are unable to meet other aspects of private life, maybe family life, and even asylum claims. But this particular case in the Court of Appeal is quite an interesting one. It brings together and draws all the threads of the various cases that we all cite quite regularly. I've set them out here in this slide: Kamara, Parveen, and Lal. But what the Court of Appeal reminded us here is that when you're looking at whether there are significant obstacles to a person's reintegration, it's a practical test which must take into account objective evidence. So it's not just an individual saying there are going to be obstacles. You have to demonstrate what those obstacles are and put evidence forward. Now, this was a particularly interesting case. This was an individual from St. Kitts and Nevis who arrived in the United Kingdom in 2016. She claimed asylum, and this was refused. So she appealed it, as you do, to the, I'm just going to stop for a second. I can see a Q&A. I'm going to make sure that I'm right. Thanks. Yeah, sorry. I just wanted to make sure that there was nothing in the chat box and you can all hear me okay. And I've moved a few slides ahead. Sorry. So coming back to this, yes, so she appealed the decision of the Secretary of State, and she also argued that there would be very significant obstacles if she was going to go back because she was very scared, and this was all based around her asylum claim. The first-tier tribunal rejected the asylum claim, but found that based on what she was feeling, there were very significant obstacles to the integration. And this, she subjectively believed that she was in danger. Now, that's not to say that you can't argue that there's a subjective fear which would impact on someone's private life, but you have to front load it with medical evidence if it's going to impact them, their mental state, or any other way that you say that it's going to impact them. You need to front load that application and put that evidence before the Secretary of State or the tribunal if it gets to the appeal stages. So the judge in this case, they decided that her subjective fear would mean that she would be unable to integrate back into life in St. Kitts. Now, of course, the Home Office, they appealed it to the upper tribunal. They said that the tribunal had not applied the very significant hurdles to integration test properly, and they'd failed to provide adequate reasons for the conclusion. And the upper tribunal then set aside the first-tier decision, and then there was another hearing, and they remade the decision themselves, dismissing the appellant's appeal. That led to an appeal to the Court of Appeal, which is this decision here, and it's procedurally unusual because the appellant challenged the first-tier decision to, the upper tribunal's decision to set aside the first tier's decision, but also then the remaking of the decision. So it was a twofold appeal, and the Court of Appeal granted permission only in respect of the first part, which was to set aside the decision. And the appellant's argument here, I'm taking you through this because it's important to understand how we get to this point, but also looking at private life in the context of these kinds of cases, which we often forget about. So the appellant argued in that the tribunal had carried out a broad evaluative assessment, which we know is the test as set out in Kamara, and that they were entitled to reach the conclusion they did, and that the upper tribunal was not entitled to go behind that. But the Home Office, on the other end, argued that what the tribunal, the first-tier tribunal, had not done was they had overlooked evidence to say that there was sufficiency of protection in St. Kitts and Nevis, that this individual could go there. She had a subjective fear, but she could go and look at sufficiency of protection, contact the authorities, and more significantly, she had family connections and local knowledge, all of which would help her reintegrate. And they said that, of course, the secretary of the first-tier tribunal had not considered all the evidence and given insufficient reasons in relation to this particular assessment. Excuse me. As I said, the Court of Appeal considered all the relevant tests, and they set out, it's a broad, they acknowledge, it's a broad evaluative judgment. The obstacles to reintegration must be assessed, and then a decision be made on whether they're very significant. And then reasonable steps that can be taken to avoid or mitigate the obstacles must also be considered. And that in this case was sufficiency of protection, family links, and so on. And how they concluded this case was that the first-tier tribunal's approach appears to have been to identify an obstacle to integration, that is her fear, and from that point move directly into determination that the legal test was met. So it's as simple as that, and that was not the correct way of doing things. It's an interesting read, but it's just that this case now pulls together all the various authorities and the way in which these cases have to be dealt with or should be dealt with, and what we ought to be doing. What do we take from this? And sorry, I've moved the slide ahead, is, as I've said, that the test is a practical one, and it's up to us to put together the evidence in terms of the practicality of an individual's return back. And remembering, of course, that this was in the context of an asylum claim of a case of a country that we often don't see. So it's worth putting together if the applicant is saying that she can't go back and live as she did before, putting together elements of the private life and addressing these issues separately when you're doing the application, or even, as I say, at appeal stage. On this note, I think there's a case that we often overlook in asylum claims. This is the case of JA. It's many of you will already be familiar, but I personally do overlook it sometimes. And it's a case where a person often has a well-founded fear of persecution or serious harm, but they don't want to make an asylum claim. They want to rely on or these issues or the factors that arise in so far as a fear is concerned in a human rights-based application. So you'll see a private life application or even a family life application, but they'll additionally add into their fears of returning. And these factors can include gender-based violence, discrimination, a risk of kidnapping, lack of conformity with religious or cultural expectations, interfaith relationships. That's a common one that I've seen with reference to a number of Appendix FM cases, and general political unrest. Now, on the facts of this case, is the case based on an individual, a Nigerian family who did not want to return to Nigeria due to the high prevalence of kidnapping, and they wanted to shield their son from the extended family's religious traditions and customs. So the court decided they were under no obligation to make an asylum claim, and individuals may well have good reasons for not deciding to do so. It may be, and I had a case many years ago. I say many years ago, probably about 5 years ago, and an individual was very clear that they did not want to claim asylum, that they wanted the issues within their claim. It was a Nigerian case as well, and there was it was I can't remember, there was an uprising up, I think it was in the north, and they said they wanted things to settle down, but because it was so uncertain at the time, and they'd been waiting for months and their leave was about to expire, they wanted to make a human rights application, ask for leave based on what was going on in the country, because they belonged to that organization and they were connected in some ways, but they couldn't show the relevant asylum criteria was met. And in any case, as I say, they wanted to go back to Nigeria. So they raised these issues with reference to the human rights application that they made, front-loaded it with the evidence on sufficiency of protection, internal relocation, and other elements, and why they couldn't return. They were unsuccessful for various reasons in my case, but with reference to this case, you can see that the correct approach that the Home Office or that the courts have said that the Home Office should take is to give an individual an opportunity to claim asylum, but if they decline to proceed to consider the issues in the raised in the context of a human rights claim, then that needs to be considered in the application that they've made. If they don't consider that in the application that's been made in the refusal, let's say if they're refusing the claim and then it gets before the first tier, then the judge themselves will have to consider those elements. But what's important from our end then is to ensure that you, in the application, the first initial application to the Home Office that has been made, this has been properly set out. Front load why they don't want to make an asylum claim, because that's an issue that will arise, that you could have made an asylum claim and it could be taken against them negatively. And you'll see here at the head note 3 that a failure to for a person to make a protection claim when the possibility of doing so is drawn to their attention will be relevant to the assessment and on appeal to the first tier tribunal. Depending on the circumstances, the assessment may well be informed by a person's refusal to subject themselves to procedures that are inherent in the consideration of a claim to a refugee or humanitarian protection status. So it's a matter which can work against them if they haven't properly articulated it with reference to the initial parts of their claim. If they're raising it later, at a later stage, they can well raise it by way of Section 120 notice. It may be, it's going to be a new claim, a new issue. So they will need the permission of the Secretary of State. So it's all things to be aware of when you raise it. Of course, if it might be a matter that during the course of a private life claim, it becomes apparent later for various reasons, things have changed. So they need to add those elements to their claim. So it's worth thinking about these things at the outset if you see that your client's raising matters which are akin to an asylum claim. And that takes us on to this aspect of private life and returning residents. So this is a really, really interesting case. It's a very recent case, 2024. And the issue that arose here is whether, I've set it out there, the private life aspect of Article 8 of the ECHR is engaged when a resident, non-national, who was granted indefinite leave to remain and whose travel document had been lost or stolen whilst abroad seeks re-entry to the United Kingdom to resume their life in the United Kingdom. I have set out a news article there because it's worth reading. It's a very interesting case, and took many years until it was resolved and got to this stage where this individual who was stranded outside of the United Kingdom was able to return back. I will just take you through the facts of this case because it's worth thinking about when you're looking at an entry clearance case. So this is returning residents with reference to entry clearance. This individual was a national of Somalia. He arrived here as a refugee in 2000 and I think it was 2000. Yeah, it was 2000. In 2000 with his mother and his 2 siblings. His father also arrived here. They came under the family reunion rules, so they joined their father, who was granted refugee status, and all of them were granted indefinite leave to remain in 2004. Now, Mr. Ali suffered with TB, and what he decided to do was go out to Djibouti in Ethiopia, Djibouti, sorry, and make to get some for. He went to Djibouti for the warmer climate, given his health state, and stayed out there for a while. But whilst he was there, he lost his travel document, and he went to the British Embassy in Addis Ababa. I think that was the nearest one, and he sought help to obtain a travel document. They weren't very helpful. They couldn't find any records for him, and this was ongoing. He went a number of times. His mother was providing him with whatever evidence she could from the UK, but literally they refused to assist him. This led eventually to his family here in the United Kingdom. They were granted British citizenship in his absence, but it led to his indefinite leave to remain lapsing. They couldn't find any records of it. They couldn't find records of his travel document, let alone his indefinite leave to remain. But it lapsed because there was a 2-year absence from the United Kingdom. So we're looking at nearly him seeking help between 2009 to 2010. And then in 2010, he thinks, right, I'm going to make an application to return back. Even if it's lapsed, he has the route to return under, I think I've got it here. You'll see it here, and I'll go back to the previous slide. So you've got the route here. If it's less than 2 years absence, you have, oops. If it's less than 2 years absence, you look at Rule 18 and you can come back into the United Kingdom. And these are the matters that you need to prove. No need to apply for entry clearance. But over 2 years consecutive, automatically you lose your ILR. But here at paragraph 19, you can make an application. And all you have to demonstrate, you have strong ties to the United Kingdom and you intend to make the United Kingdom your permanent home. That's not an issue in this individual's case. He was already based in the United Kingdom, indefinite leave to remain, just simply gone on holiday and stayed, lost his travel document. So in 2015, I think it's 2015, he was actually able to make an application for entry clearance because the family was of limited means. So they, by the time that they were able to gather funds, make the application, it was nearly 6.5 years that he'd been outside of the United Kingdom. And it was found that when his claim was refused, it goes to an appeal. It was found that he was outside of the United Kingdom voluntarily, and the appeal was dismissed. I think there was, yes, it was an appeal, and it wasn't appealed any further. What then happens in 2017 is that he gets the assistance of his MP, and the Home Office say, well, we don't have a record of this individual at all. And I'm not sure who his representatives were by 2019, but they helped him then at that stage to make an application under adult dependent relative. And one of the key features at that point became his private life, and that there was a focus previously on family life, but the focus became private life, and whether, given he had been previously granted indefinite leave to remain and his travel document had been stolen, whether Article 8 was engaged. So quite fact specific, but interesting to see with reference to those who might have leave in the United Kingdom at any point, excuse me, or connections, or having been in the United Kingdom at any point, and having to apply for entry clearance then when abroad. Now, the reason his appeal back in 2020 was dismissed, and it eventually gets to, the reason it was dismissed was because the judge in the first tier looked at this case of Abbas, which is again a Court of Appeal case, and the issue on the facts of that case was whether an individual state had a positive obligation on grounds of private life when no relevant family life exists to grant entry clearance for an adult to visit an elderly relative located in the United Kingdom. Again, that's very specific. As I say, this person had never, in Abbas, had never entered the United Kingdom. And so in that case, the state had found that there was no positive obligation on that Article 8 was engaged in that particular case. So that's the approach that the first-tier tribunal took in the case of Ali. And in considering this issue, the Court of Appeal found that it was quite fact-specific, that what they were looking at was a resident non-national who had been granted indefinite leave to remain and whose travel document had been lost or stolen when abroad. And therefore, looking at the case of Abbas, it could be distinguished. It was a different scenario. They were looking at positive obligation on family, on private life, where no private life had been established previously. And in this case, the converse applied. So on that basis, the applicant was, in the case of Ali, the applicant was found to have engaged Article 8 of the ECHR and happily has been granted leave, but I think following the Court of Appeal decision. But as you can see, it's a very long history since 2008, where he found himself without leave and without recourse. So it's worth considering when individuals say that they've previously had leave and trying to establish what kind of leave they may have had and looking at private life and the context, or in the context of applications that you might be making for them. What I wanted to say was, just to flag here is that, of course, the issue here, and issue will always be about positive obligation. It's not going to be that a person applying for entry clearance from outside will never be able to demonstrate private or family life if they've never been to the United Kingdom before. They may well have had that with an individual before that individual came to the United Kingdom. And I think I'm going to deal with probably a case like that right at the end when I'm looking at exceptional circumstances. So we'll come back to the private and family life of someone applying for entry clearance. I just did flag this case here, R3, which just reaffirmed what was said in Abbas, but it's worth again looking at if you are considering scenarios similar to this. I've already taken you through this aspect of it. Just remember, of course, it's a fact-specific analysis in any case that you're looking at for entry clearance, and making sure that you address that very initial stage of why a person's Article 8 rights are engaged. Limbo cases. This is another interesting species, I'd call it. It's similar to the case of Ali, in the sense that, but this individual was in the United Kingdom. It's in the sense that this person has been left without leave for a very long period of time. The facts of this case are that this was an individual who'd been living in the United Kingdom for over 26 years. Excuse me. And he had no immigration status. He was not entitled to status on, if you look at it, 26 years, you think, oh, straight away he'll come within the 20 years rule, but he wasn't entitled to any status. And that's because it was considered that it was his own fault. He'd repeatedly been found. Sorry, let me rewind there. So he had committed several criminal offences, and that was why he wasn't being granted status. And what had happened in the interim of those 26 years, he'd been removed a few times back to Belarus. I think it was a few times to Belarus, but certainly in 2001. And what he said to the Belarusian authorities was that he wasn't a citizen there. And so they refused to accept him in country. He was returned back to the UK. As I say, he made an application to the courts, but they refused it on the basis that he was not entitled given the criminal offending, and you'll see that from the first slide. Suitability applies in this case. And in the meantime, he's left in limbo. He can't work, he can't rent, can't get accommodation, access to emergency. He has no access to anything but NHS emergency care. He becomes mentally unwell, and addiction issues arise also, and he commits further offences, including false identity offences, etc. And the upper tribunal, on the facts of this case, when they looked at it, found that there was a genuinely exceptional case, and although the background was quite, when you look at the background, he possibly it would weigh against him in relation to any leave that he might be granted. It was the factual nexus of this case that meant that he ought to be granted leave on human rights grounds. It eventually went through to the Supreme Court, as you can see, that's in 2024, and they found that they rejected the Home Office submission that an individual can never complain of an impact upon private life in relation to matters which arise as a foreseeable consequence of a deliberate action that they themselves have taken. And that's looking at this individual who's saying, I'm not Belarusian, although he was, and he's been removed from his country. He's back and forth. So he's, and then his criminal offending behavior, that was all seen to be his issues that arose, his return to the UK and being left in limbo was all as a result of issues that he himself had raised, and there were issues that he had to take responsibility for. And the Supreme Court, but the Home Office argument in relation to this case was that he can't engage private life just because he's got there are a number of issues that arise, and they're all his fault. The court said that can never be the case. You can, even if it's your fault, Article 8 can be engaged. He could still demonstrate he's got a private life. The real issue is going to be proportionality, and looking at proportionality and the four-stage approach that they set out in particular is, as you've got here on this slide. I mean, it's a really interesting, it's a difficult case because it led to this individual and the court's finding that there was a need to maintain public confidence in the operation of immigration control, which had been overlooked, and the upper tribunal, in allowing the case, had attached too much weight to the fact that 20 years of residence, because they had misunderstood, this is a direct quote from the Court of Appeal, the significance and the role of the 20-year rule. A grant of status on that basis is conditional on other criteria also being met, which was not on the facts of this case. So they reframed the proportionality question, and it's the question on the facts of this appellant's case was whether the United Kingdom, which had been forced by AM to act as his involuntary and unwilling host in this way, is in violation of their own very strong public interest, is subject to a greater obligation than under Article 8 to make further provision for him out of public funds and allow him access to the employment market so that he can compete for jobs with citizens and lawful immigrants. And that was how they summarized this particular case and rejected his claims. And it's reminiscent, this particular case is reminiscent of the IMA provisions, which Julian is going to take you through a little later today. And this, it may well be, now that we have a regime change, that things change a little bit with reference to people who are in limbo like this. But it's worth keeping this kind of case in mind. And again, everything is completely fact specific. I'm just going to move away from that and go through to this case. Excuse me for a minute. This is looking at EUSS and Article 8. We all are very familiar by now with CHELIC. We've done a number of webinars on CHELIC. This was a similar CHELIC case. The individual had had applied on the basis of a marriage that took place after the 31st of December 2020, had no relevant document. And it was argued that the decision to refuse his settlement scheme application breached his Article 8 rights. And there was an attempt to broaden the ability to raise human rights and appeal beyond the limitations, which you can see at section 113 of the Nationality, Immigration and Asylum Act 2002. But the tribunal found that if someone wants to raise human rights in an appeal, they have to, sorry. They will need the consent of the respondent under 9(5), and especially if it's not relevant to the substance of the decision being appealed, so it's a new matter. And often we know that it's just the Secretary of State's not going to give consent, so the best way forward is to make an application. But this just underlines those what we knew already was happening in cases where an application was being made under the EUSS on these facts, the facts of these kinds of cases. Now, you'll have to give me a minute. Sorry, I did say I do have a cold, so but we are getting there, and I am reaching one of the last areas that I was going to cover, and I already said that I had covered this quite extensively back in February, but I will recap for those who were not at the February webinar. And let me just go to the next slide if I can. There we go. Exceptional circumstances. Now, you make an application under Appendix FM. If you're unable to meet the rules, you go to GEN 3.1 and 3.2. That is the equivalent of looking at the rules it's looking outside of the rules. What the Secretary of State did was bring it within the rules. So it's looking at Article 8 of the ECHR. If an application is being allowed, it's still being allowed under the rules, but in our minds, we're looking beyond the criteria of Appendix FM. And how do we do that? In particular, I covered this because of the minimum income rule that had been introduced, where individuals were not going to be able to meet the threshold that had been introduced. And they were looking at this particular part of the rule, GEN 3.1. And what they would have to do, I'm repeating, or I want to read this because it's important. You can see the bits that I've highlighted here, that they would have to provide financial, so they can't meet the financial requirement. And it was evident, sorry, if I can follow that, it was evident from the information provided by the applicant that there are exceptional circumstances which could render refusal, being the operative word here, render refusal of entry clearance or leave to remain in breach of Article 8 of the ECHR. Okay, now this part here, 3.1, is looking at alternative sources of income, and you can't avoid the minimum income rule, but you're looking at paragraph 21A2, whether there's a credible guarantee of sustainable financial support to an applicant, their partner from a third party, credible prospective earnings from a sustainable employment or self-employment of the applicant or their partner, and or credible, reliable source of income or funds for the applicant, which is available to them at the date of application or will become available to them during their period of limited leave applied for. So once they're able to demonstrate the finances by reference to another source, they have to also demonstrate that there are exceptional circumstances which could render refusal of entry clearance unjustifiably harsh. So it's a twofold test, and sometimes we forget that. So I wanted to emphasize that. Now, there is one other part to the rules, and that is GEN 3.2, which is where they can't meet the minimum income threshold at all. And what they do is they look at GEN 3.2 and look at whether the refusal would result in unjustifiably harsh consequences. You can see there's a difference there between the two slides. Here it's could render refusal of entry clearance. This is if they show they have finances by a third party. So it's a lower threshold because it's a could, it's a possibility, and would being a definitive, they have to demonstrate that there will be unjustifiably harsh consequences for them. They're not looking at any financial support here, or the minimum income threshold is plain test of would result, so a higher threshold. What do? You look at the exceptional circumstances as defined in Agyarko, and what I wanted to do was just flag up the guidance with family and family policy, family life as a partner or parent and exceptional circumstances, just to underline the difference that you see within the rule itself is acknowledged by the Secretary of State in their guidance. You'll see here, just to make more sense of it. And I'm going to take you through the facts of a specific case so that it all comes together and makes sense. But I wanted to outline the differences here first. See here, paragraph GN 3.1 sets out the threshold test to be met before it's necessary for you to consider such other sources. You will ask whether the refusal of the application could breach the ECHR because it could result in unjustifiably harsh consequences. Okay, and the next page or the next slide is the threshold to be met before it is necessary to consider other credible and reliable sources of income, financial support, or funds under the minimum income requirement is not as high as the ultimate test under paragraph GEN 3.2, and that is that it would result in unjustifiably harsh consequences. Why have I brought this up? It's because a colleague of ours in Chambers very recently had a successful case, and actually two colleagues, and I think I have it up here for you. This is one of the cases. Right at the end of this slide, you'll see it. It's an unreported case, so don't rely on it insofar as it being able to support your case. But what it does, why I have flagged it for you, is because it's worth looking at how the could and would applies in these different cases, or how it's distinguished, or how a judge might distinguish it, or how you might want to present your case to distinguish the two. Now, that's one case, but the facts of the case that I want to take you through is more detailed, and it's not yet up on the unreported database, but it will be up there soon. But on the facts of that case, there were two British nationals. The appellant was married to a British national. The appellant was an Indian national, and they had a child who was an adult child now, who was a British national, also living with them. All three were living in India. The appellant's wife and son came to the United Kingdom to settle here, and the appellant himself sought to make an application to join them in the family unit. So when they moved, he sought to accompany them, but no one could meet, he couldn't meet the financial eligibility requirements, or his wife wasn't working, so she couldn't meet the financial eligibility requirements. So he remained outside the United Kingdom. But the son, who was now an adult son, started to earn monies, and he was able to demonstrate, going back here, where we are, yeah, he was able to demonstrate that he had sustainable financial support, a credible guarantee of suitable financial support to the applicant from a third party, the third party being the son, who was now earning monies. And he put himself forward as a financial supporter, as it was, and the appellant applied for entry clearance under Appendix FM of the immigration rules. It was accepted that he couldn't meet the financial requirements. So looking at GEN 3.1, the income of their son was considered. Now, the respondent did not accept that the son was in a position to provide financial support to the appellant, and they stated that if he were to provide the appellant with the minimum required, he would have only had a very small amount of money left for himself. And they also stated there was no reason why the wife could not go back to India to resume her family life with her husband. Now, there were a number of health issues that she had, and she had to stay in the United Kingdom for her treatment, and there were a number of other issues connected with her, with why she couldn't return back to India to be with her husband. So when it came before the upper tribunal, they considered, and I'm just going back here, they had to look at the different meanings of the different words could and would, and the thresholds, because of the arguments being made by the Secretary of State. So you'll see here, and once that case is reported, it may well be reported. If it's not reported, you may find it in the unreported database. But just so that I'm flagging some of the pertinent issues from it, it was highlighted that looking at GEN 3.1 first, the son, on the facts of the case, had the financial means to provide for the father. So I think even though the Secretary of State found that he didn't, they went back and looked at the son's finances. He was able to demonstrate that he had sufficient finances in relation to supporting his father in the United Kingdom. But the second part of that was to look at whether the refusal of the application could result in unjustifiably harsh consequences. And what the parties put forward, or what the appellant's wife put forward, is that there would be a separation from her husband because she couldn't leave the United Kingdom. That was an unjustifiably harsh consequence, and it was likely that if he was refused, she would not go back, and hence the separation. It's quite nuanced, but very interesting. So it's worth keeping in mind when you have a case like this under Appendix FM, what test you're looking at if they can't meet the minimum income requirement. And if you're looking at the could test, it's a lower threshold. So it's just a possibility of something happening, whereas would, which wasn't being looked at on the facts of this particular case that I'm talking about, is that something was likely to occur. Okay, and would was used or considered in Agyarko, and Agyarko, I think at paragraph 48, and I've already cited that there. And it reiterates what we already know about there being a definitive, unjustifiably harsh consequence. I've just flagged a few other things there, just to underline what I've already said. GEN 3.2 brings the test of proportionality under Article 8 into the rules. So that's what I'm saying about, even though we, in our minds, we still think about it being outside the rules, it's actually within the rules. So you can still, you can make that distinction when you you're putting your case forward. And I just want to underline again, GEN 3.1 was introduced to give effect to what the Supreme Court said in MM Lebanon, if anyone remembers those minimum income requirement threshold cases of 18,000 when 18,600 was introduced at that point. So that's why the rules now reflect that decision about alternative sources of funding. And I think that brings me to the end of what I wanted to talk to you all about today, insofar as private life is concerned. And I think I finished slightly, maybe 5 minutes earlier. Yeah, I did finish 5 minutes earlier, so I'm happy to take questions from you all. And I think there might be some in the Q&A box, unless those are for those were for Richard.
Oh, I think that some of them are for you.
Oh, okay.
Yes, I think just the first few are for me, and then I think going on for you, there's one about getting ILR
Okay.
early, which I don't think was really about the appeal procedures. Yeah.
So let's have a look at I'm looking at Masood's question, and I have two questions. He says, in private life applications on the basis of 20 years, how TOEIC charges of deception could affect the applicant. So they can affect the applicant because they could raise suitability as an issue, but they have, so the process would be the same, but they have a duty to, first of all, come to the applicant and say, this is the issue. What we are going to raise ETS as an issue, and then you have to then put the evidence forward, as you would do in any TOEIC case, about why you say that that doesn't apply to him, how the innocent explanation and so on. So it is an issue that can arise in 20 years residence cases under suitability. So that's that one. And then Masood, your second question was, an EU citizen lived in the UK with his mother, studied and worked, but left UK in 2016 for work, and now wishes to come back and apply for EU settlement, whether applications should be considered as a returning resident. Well, it depends what status he would have had in 2016. Returning residence is only for indefinite leave to remain. If you had indefinite leave to remain, those individuals would be counted as a returning resident. So you'll have to look at that. The other thing that I think you would be looking at in those kinds of cases is if the mother has EU, if she has some sort of EU status, then the individual can, if the individual is a child, so that's what you're saying, they are a child, and if they can show the child, if they're over, depending if they're under 21 or over 21, if they're over 21, they have to show dependency, that their mother was that they were dependent on their mother for financial support. So that would be interesting, and you'd have to investigate the various aspects of that individual's leave or their life outside the United Kingdom and the relationship that they've had with their mother. So I hope that answers that question. And then I think, Humberto Ferrarini, you have a question about a child who entered the UK as a tourist under the age of 18 and was granted a further leave to remain in an appeal as a dependent of her grandparents, British citizens with guardianship. Visa was issued for 2.5 years. She's now over the age of 18, needs to extend the visa. Is it possible to extend a visa applying for indefinite leave to remain under paragraph 8 of the rules, or is there another route? I think it's I'm trying to think about, she was granted leave to remain on appeal if she because she entered as a tourist. You need to look at the 298 quite carefully. It may be a possibility, but the point here is that she wasn't granted leave under for entry under 297 in the first place. So I think there may well be a difficulty, and plus the child is now over the age of 18. So it may well be that that's a difficulty. Excuse me. It's also worth considering if she entered as a tourist under the age of 18, how long she's been in the United Kingdom, whether she can apply for citizenship on that basis, whether she can apply for indefinite leave to remain, or go and look at calculating her half the life test. Well, no, because with the half the life test, you would only get the 30 months anyway. Yeah, I think the best thing is to look at whether she can apply for British citizenship, nationality as a child, depending on how long she arrived and how long she's been in the United Kingdom. And those would be discretionary routes for citizenship. It's a really complicated area. I would say get advice from someone in relation to, if you're looking at nationality and children, in relation to whether a child, depending on the chronology, can apply for citizenship. And then I'm going to see if there are any other questions. Okay, it says under 20 years rule, exactly what time the application is to be sent. Is it 28 days before the 20 years passed? I think you'll have to refer back to the guidance. I think the guidance says it's probably, you can, with the 20 years, you can still do the 28 days as with other applications. And remember, it's an application, the date of the application for the 20 years. And if it goes to an appeal, by the time it gets to appeal, many of us will know that those individuals have now got their 20 years. And what you've got to remember, it's a human rights appeal. And whilst the human rights appeal, it's not by reference to the rules, what the human rights appeal does look at is whether you can meet the rules. And the rules specifically say at the date of applications that an individual ought to have demonstrated 20 years. Sometimes the judges can apply that quite strictly, but often, depending on how the case has been put forward, how it's been front-loaded, how it's been argued, what grounds of appeal have been put forward, including whether you say to the Secretary of State any time before the appeal, we're now at 20 years, can you reconsider the case, and whether they've looked at it in the review, which you should, and I would advise all of those things, put it for, as soon as the 20 years come up, put it forward for someone to consider. Then it doesn't become a big issue at an appeal stage. But yeah, often it's the date of application. It can be a sticking point in many applications under the rules. Radinda, hi. The unreported case. I'm going to have a little search on the unreported database if I can, and I need permission to see whether I can disclose it if it's not on the database. So it's a very interesting case, but I have put one of the links to one of the cases similar to the one I talked about, because that is on the unreported database. If not, I can circulate it at some point to Wasantha for everyone to be able to see. Okay. And then Humberto, you said that she's only been in the United Kingdom for 2.5 years only. This is going back to your question of whether the child who entered as a tourist under the age of 18 could remain in the United Kingdom, and how. I think it makes it a difficult one. I think you need some advice. If you set out a chronology, you'd need a proper advice with reference to the factual nexus of her case, because it sounds very fact specific, to be honest. So yeah, I think that's all I can say to you. It's quite an interesting case. So yeah, get someone to advise you on the nexus and citizenship, really. And I think that's worth it, because once you know that, and I think we shortchange ourselves that we don't get the information beforehand, we just make the applications. If we kind of get that information, even if it's in the form of an advice from counsel or someone else, you're able to take that information then and put it in an application, which, you know, it strengthens the chances of succeeding in an appeal. And that, I think, brings me to the end of questions. I don't know if there's any questions you'd like to answer, Richard, from your slot, if we still have time.
I've just unmuted. Yes, actually, perhaps I could come in on the business about putting in an application before you've actually come to the end of 5 years or 10 years, whatever. Now, this, I think, was started by Aisha early on when she mentioned a case that an application for indefinite leave after 5 years lawful residence. And I've been asked to start my video as well. Okay. Anyway, she was asked, or rather, she asked whether it was correct what was said in that case. The Home Office refused her application or refused the application under the 5-year rule because she was, the application was 3 days before the 5-year period had been completed. Anyway, I couldn't find anything. I was looking to see if there was anything about the 5-year rule and about that, but I did have a look at the long residence guidance issued on the 11th of April this year.
Yeah.
And that reminds caseworkers that an application made before the 28, sorry, any earlier than 28 days before the 10-year period has been reached must be refused. But if it's 28 days or fewer before the 10-year period is reached, then normally they should grant. So
Yeah.
it would be odd if you're 3 days before the 5-year period and you're refused, but you're 28 days before the 10-year period and you're granted. And it could be that whoever refused the application under the 5-year rule was simply wrong.
Yeah.
I think
I
that's
think
more probably the case.
I
And
agree. Yeah.
yes, yeah. So anyway, if anyone else happens to know or can look it up in the meantime, during the rest of the webinar, it would be great if you could let us know through the chat box. But anyway, Samina, I think you've done us proud. If we were all together in a lecture theatre, we could all give you a round of applause. But I think thank you on behalf of AstenJ and all the participants here today for your very excellent talk, as usual, and for all the talks you've given us in the past. But hopefully you'll be with us this afternoon for the panel session.
Thank you. Thank you. And thank you, everyone, and AstenJ especially for organising these amazing webinars and for you chairing them. It's always such a pleasure, so well organised, and delegates with really interesting scenarios, questions. But yeah, and you know, Sarah and I have completely enjoyed these interactions essentially. But looking forward to the afternoon session, everyone, and I'll hand back over to you, Richard.
Thanks very much, Samina.
Thank
Well,
you.
everybody, you'll be pleased to know that we now have a break, and the timetable has changed somewhat because Nishan Paramjorti can't be with us today. So it means that every speaker will have longer to give their talks. And we now, well, it's 11:45 now, so I think we'll need at least a 10-minute break till 11:55. And then I'll be coming on to give my immigration law update. And after that, we'll have an earlier lunch break than was originally scheduled. So if we can reassemble at 5 minutes to 12, I'll see you then. Thank you. But I'm afraid it looks as if I won't be able to use my slides at all for this session, in which case I'll have to rattle through the course notes. I'm asked to start my video. Of course, you'll have the slides anyway on your course notes. So do have a look at them. And in the remaining time that we have, because I'm aiming to finish by, well, I think it's going to have to be about 1:45 now, as we've been so delayed starting. I'm just going to rattle through my course notes and pick out some items which I think are particularly interesting or even amusing. So I'm going to leave out the first few paragraphs, which are to do with salary thresholds for the work routes, because that subject is being catered for by Sarah Pinder this afternoon. So just very quickly going on to income thresholds for Appendix FM. Well, everybody knows that from the 11th of April, the minimum salary threshold for the sponsor of somebody on the partner route went up to £29,000, and it's set to rise to 34,500 later this year, and next year to 38,700. But who knows, the new government might roll back on that, because it has been subject to a huge amount of criticism. Well, that's for the normal 5-year route. The 10-year route is for people who can't meet the minimum income requirement, or who are here unlawfully and who face insurmountable obstacles, continuing their family life abroad, or who have a child which can't be expected to leave the United Kingdom. So there's no change to the 10-year route. So moving on then to the next paragraph, we have appendix victim of domestic abuse. And that benefits quite a number of people, as you can see, including people who have an EEA connection to the UK. So that expands the ambit of the policies on domestic abuse. And also, notably, the issue of transnational abandonment has now been taken on board by the Home Office, and Appendix Victim of Domestic Abuse includes provisions for a person who has been who has gone abroad. It's usually a spouse with her husband, and the husband takes her abroad, usually takes her passport as well, and then abandons her, hoping thus to get rid of a troublesome wife by leaving her abroad. And this is now provided for by making provisions for the wife to come back to the UK and getting entry clearance for settlement in the UK. So moving on from spouses, you'll see in bold Appendix Administrative Review, there's not much change in that, no changes of substance anyway, but it's been redrafted as part of the project to simplify the immigration rules. One thing I'd just like to mention is that administrative review doesn't allow you to introduce fresh evidence unless you've been refused on the basis of making false representations or practicing deception. And you can introduce fresh evidence to show that you didn't do that. Now, the refusal of a visit visa doesn't engage, doesn't give you the possibility of an administrative review, but you can nevertheless ask for a refusal of a visit visa to be reviewed by the entry clearance officer. However, you can't introduce any fresh evidence at this stage, because the Home Office reaction would be, well, if you've got fresh evidence, you should make a fresh application. Now, this is why it's not really a good idea in the great majority of cases to threaten the entry clearance officer with judicial review for refusing your application for a visit visa, because it's far simpler and cheaper to simply make a fresh application, and you can use your fresh evidence then. Now, many people find that when they do make a fresh application, they get refused again, perhaps for the same reason as previously. But even so, I think you would have to make sure that this really is something that you're never going to be able to get permission to come if you don't make a judicial review. You've really got to exhaust the possibilities of making a fresh application before I think it's worth it to apply for permission to make a JR application. Now, administrative review has also been available hitherto for people who are applying for the EU settlement scheme. But now it's become more or less redundant because, first of all, admin review was taken out of scope for decisions under the settlement scheme made on or after the 5th of October last year. And now decisions made before that date have also been taken out of scope. So what you've got left is an appeal to the tribunal under the Citizens' Rights Appeals regulations. So you have to use your right of appeal instead of applying for admin review. It's no longer possible to use both. Moving on to definitions under Part 1 of the immigration rules. The definition of partner in paragraph 6 has undergone a change since the beginning of January, in that it's no longer necessary for an unmarried partner to have been living with the sponsor in this country in a relationship akin to marriage for at least 2 years. Now they just have to have been in a relationship similar to marriage for at least 2 years. Although proving that you've been in a relationship will be easier if you've actually been living together as well as being in a relationship. But there it is. It's easier now to be a partner for the purposes of the immigration rules. Now, there's been a more radical definition of another familial term, namely parent. There's no longer in paragraph 6 any reference to stepfather or stepmother. And instead, we've got a tripartite definition into 3 sorts of parent. So you can be a biological, legal, or adoptive parent. And this seems to me to have at least one problematic description, and that is the definition of legal parent, which includes the birth mother where the child is not genetically related. So what can that mean? Now, it seemed to me that this was a reference to surrogacy, but the Home Office explanatory memorandum doesn't say that. It says that the Home Office intends this definition to recognize same-sex parents. And so the definition of legal parent goes on to add the spouse or civil partner of the birth mother at the time of the child's birth. But I'm still very puzzled about how a birth mother who's not a surrogate could be not genetically related to the child. So maybe somebody could come up with an explanation of that. And male same-sex couples would have recourse to adoption. And there's a new definition of adoption in the introduction to the immigration rules, which I think also is a bit curious because you'll see there's Little Roman 1 and 2. Little Roman 1 says that an adoptive parent is one who, when habitually resident outside the UK, adopted a child in accordance with a decision taken by the competent administrative body or court in a country whose adoption orders are recognised by the UK. Now, that seems to be a curious amalgam of two different requirements. The requirement to be habitually resident outside the UK was for de facto adoption. The prospective adoptive parents had to be living outside the UK for 18 months and living with the prospective adopted child for at least 1 year. But that was different from being a child being adopted by a competent administrative authority or court whose adoption orders are recognized in the UK, because a de facto parent is one whose adoption is not recognized by any court or administrative authority in another country, often because there is no adoption procedure in that country. So this Little Roman 1 seems to be amalgamating two different things. And then the second definition is for a child granted who is being adopted within the UK. The adoption procedure is being completed in the UK. Well, let's skip the next couple of paragraphs and come to the new appendix adoption itself. And this actually shows you that there are 4 kinds of adoption now recognized in the United Kingdom. So there's Hague, adoption under the Hague Convention, when the child is adopted by or adopted in another of the parties to the Hague Convention. So we're a party to that convention. And so if the child is adopted in another country, which is a party to the convention, then the child simply can come to the UK and is recognized as the adopted child. Now, then there's the recognized overseas adoption, because the adoption took place by order of a court or administrative authority in a country whose adoption orders are recognized here. And then there's the de facto adoption, and then there's coming to the UK for adoption. You have to get entry clearance for the child, and you, the adoptive parent, have to be scrutinized by the relevant authority in the United Kingdom, who must be satisfied that you are suitable to adopt a child. So you have to be kind of certified as suitable to be an adoptive parent before you can bring a child to the UK to be adopted in this country. Now, I've got to make a slight correction here, because I say just a couple of lines under these bullet points. Paragraphs 309A to 316F of Part 8 of the rules have been deleted in their entirety, and then 3 subparagraphs of the old paragraph 310 do not emerge in the new appendix. So paragraph 310 was for recognized, for adoptions in countries recognized by the UK. And certainly for the new requirements under appendix adoption, 3 of the old requirements are no longer required. Okay, and those are listed under the little Roman numbers 8, 9, and 10. Well, those don't reappear under the new provisions for recognized overseas adoptions, but in fact they do appear in two of the other bullet-pointed adoptions, de facto adoption and coming to the UK for adoption. So those requirements are still there in those two sorts of adoption. So anyway, this new appendix completely supersedes all the previous immigration rules for adoption under Part 8. So now I'm going to come to something which was puzzling immigration practitioners for quite a few weeks, but now has been resolved, as most of you, I'm sure, would know already. But anyway, I'll just go through quickly what I've got here under the heading Long Residence Puzzle. Now, the culprit was the new Appendix Long Residence, along with changes to the existing Appendix Continuous Residence. And this was because of a change in the wording of one of the paragraphs in Appendix Continuous Residence. Okay. And I'll just see if I can find that one for you. Yes, here we are. Appendix Continuous Residence, paragraph 2.2a, where the application is under Appendix Long Residence, for any qualifying period before the 11th of April 2024, the applicant must not have been outside the UK for more than 184 days at any one time, and must not have spent a total of more than 548 days outside the UK during that qualifying period. Okay, now this caused considerable puzzlement to readers, because the big change between the previous rules for long residence and the new rules coming in on the 11th of April were that previously you could not be outside the UK for more than 188 days in any rolling 12-month period, or for more than 548 days, roughly 18 months, in the 10-year period that was needed for success under the 10-year long residence rule. So a total of 548 days absence from the UK during the supposedly continuous period of 10 years residence in the UK would mean that you had broken continuity and you wouldn't succeed. Now, the way that the new paragraph 2.2 was worded led some people to believe that, and in fact, it was encouraged by the guidance given to Home Office staff by it's actually version 15.0, published for Home Office staff on the 11th of April 2024. This made it seem extremely generous, and it says at page 11 of that guidance, version 15, continuous residence will be broken if an applicant has been absent from the UK for more than 184 days at any one time, or for more than 548 days overall, where that absence started before the 11th of April, 2024. Okay, so the new provisions are that it's only 188 days absence in any 12-month period that will break continuity, and there's no 548 days during the 10 years at all. So that's the new provision for anyone starting since the 11th of April. But anyway, the guidance from April goes on to say a 10-year period completed before the 11th of April must not have total absences of more than 548 days. And for 10-year periods which extend beyond the 11th of April 2024, there is no 548-day limit. So that seems to mean that if your 10-year period straddles the 11th of April and it ends after that date, you're not caught by the 548-day maximum at all, even if, in fact, you had already clocked up more than 548 days absence before the 11th of April. So all you had to do was make your application on or after the 11th of April this year, and your previous absence of more than 548 days wouldn't count. Now, that seemed very generous, and a lot of people started applying for leave to remain, well, indefinite leave to remain, under the 10-year rule after the 11th of April. Now, so many people were applying that the Home Office paused consideration of their applications so that the policy wonks could consider whether this is really what was intended by the rule change. And indeed, fresh guidance for the Home Office staff was published very recently on the 8th of July. And this makes a very important but it's seemingly very minor change to the wording of the Home Office guidance. Now, the previous wording at page 11 of version 15, published on the 11th of April, just to repeat, says this: continuous residence will be broken if an applicant has been absent from the UK for more than 184 days at any one time. And that's exactly what it says in the new guidance. But then the old guidance goes on, or absent for more than a total of 548 days overall, where that absence started before the 11th of April, 2024. The new guidance goes on, absent for more than 548 days, not overall, but in the 10-year qualifying period, where that absence was before the 11th of April, 2024. The old guidance says where that absence started before the 11th of April. The new guidance says where that absence was before the 11th of April, 2024. The other difference is that the bullet points which are underneath the passage in the previous guidance, which include saying that for 10-year periods which extend beyond the 11th of April, 2024, there is no 548-day limit. Those bullet points have gone. So now you've just got the wording, you must not be absent for more than 184 days at any one time, or for more than 548 days in the 10-year qualifying period where the absence was before the 11th of April 2024. So you can still have a qualifying period which ends after the 11th of April 2024, but if before that date you've already clocked up 548 days absence, then you're caught. And so all those people who thought that they were going to get indefinite leave, but who had already been absent for 548 days, will now have their hopes dashed. So there it is. Fortunately for me, the clarification came just a few days ago. Otherwise, I would have had to rely on what I've put in your course notes, which now turns out to be wrong. So there we are. Now, I'd better just check what the questions and answers are, because we've got a few more minutes before I'm going to knock off and we'll have lunch. So let me just look up the Q&A box. If I can get my cursor down to that. Oh, here it is. Now, some of the questions I've already dealt with. Oh, yes, let me just see about this. Oh, no, this first one is about applying too soon. So we've dealt with that already when Samina had finished her talk. Oh, yes, here's something which I ought to say about my previous talk. When the respondent doesn't produce a respondent's review, or it doesn't come within 14 days of the appeal skeleton argument and appellant's bundle being served. Now, what penalty is the respondent liable to be suffering in that instance? Well, there would have to be, I think, a complaint to, well, there would have to be a request to the tribunal to chivvy up the Home Office to send their review. If it's a protracted delay, conceivably the appellant could seek an order from the tribunal when the matter is finally heard by the tribunal for their conduct of the proceedings, if they can show that it's caused significant damage to the appellant or the sponsor by this delay. Otherwise, if there isn't a respondent's review at all, in fact, that could be detrimental to the Home Office rather than to the appellant, because the Home Office has lost the opportunity to bring up further or better reasons for refusing the application, and has lost an opportunity to bring up further reasons at the hearing itself, because there will just be the reasons contained in the original refusal letter. Okay, so let's scroll on down. Oh, I think these are questions for Samina that have come down. Oh, here's one from TT Noah. The information from Mr. McKee concerning administrative review was most helpful. However, this is not in my notes, so not in the course notes, and I'm prone to forgetfulness. May we have notes on AR, please? So this is administrative review. Oh, well, this must be referring to what I was saying about not threatening judicial review, it's not worth it in the great majority of cases. Just make a fresh application with your fresh evidence. And I think probably that's what is not actually in the course notes themselves, but hopefully that will be sufficient for the inquiry. Oh, well, here's another. If someone is qualifying for indefinite leave after the 10 years long residence, just 4 days after their current leave to remain expires, can they put in a fee waiver application to gain time? Well, their current leave is going to expire. Well, 4 days after the current leave expires, they're going to, well, can they put in an application for a fee waiver? Can they put in an application for a fee waiver so as to extend the time? I think they can make an application anyway, can't they, before the current leave expires, and put in an application for a fee waiver as well. And if it is the case that they can't afford to pay the fee anyway, they could do that. But provided the application for further leave is made before the expiry of the existing leave, that would extend their leave to remain anyway under Section 3C. So yeah, that should be okay. And there's another question. If a child is born in the UK, goes abroad again, and is on a dependent visa, will this rule for counting away days be applicable while applying for their ILR or British citizenship? So the question is, if there's a child under 18 born in the UK, but who hasn't got, well, whose parents aren't settled or don't have citizenship, and presumably the child goes abroad with its parents, and oh, well, now we're actually getting away from indefinite leave under the long residence rule. So this is asking whether the number of days away from the UK will count against the child. Well, I think they will, insofar as they can do, depending on the number of days abroad. So, for example, if when applying for British citizenship in the previous 5 years, you have been out of the UK for more than 450 days, or for 90 days in the previous year, you've been away for too long. But the guidance actually allows you to be absent for longer than that. And the longer you've been away, the harder it is to have those extra days excused under the guidance. But it could be a lot longer than the 450 or 90 days at the point when you come to apply for citizenship. And of course, if it's the case that you were abroad when you were a child, that would also be mitigation. But I think in principle, they would count against you. Okay, well, I better just deal with another comment by the anonymous attendee. Comment regarding the fee waiver. If approved, even though you get 3C leave, the new application will be considered by the time the fee waiver was submitted. Therefore, the application will be considered when the initial fee waiver was submitted. It will not count further time, even though you have 3C leave. Please correct me if I am wrong. I think Section 3C leave does normally count, but if you apply after your Section 3C leave has expired, and you apply within 14 days of the expiry of your Section 3C leave, and you then get further leave to remain, that bookended leave when you didn't have, sorry, that bookended period when you don't have leave, it doesn't count towards the 10 years continuous lawful residence, but it would be disregarded in terms of not interrupting the continuity of your 10 years lawful residence. But anyway, I think time is now getting on. I think these other questions are probably things that we can come back to during the afternoon session that we've got for a panel discussion. So I'm afraid I've now gone rather beyond what should have been the time for our lunch break, which was going to be 12:45 to 1:35. But I think if we can come back at 20 minutes to 2, that will just be a few minutes after the intended time, 1:35, and we'll be hearing then from Julian Norman. So if we can reassemble then at 20 to 2, we'll continue with Julian and her talk about asylum. So see you then, everybody. Bye-bye for now. Hello, Julian. I think we're meant to start now.
We are.
And just to remind everybody, we're running a rather different timetable because one of our booked speakers wasn't able to make it today. So we're starting a bit earlier than on the original timetable. And I think it's getting on for 1:45. And we're lucky to have with us for the afternoon session, Julian Norman from Goldsmiths Chambers. And she's going to be talking to us about asylum claims, and in particular, the whole Rwanda business, and letting us know how things stand at the moment. So we've actually got longer than we normally would have for each talk, Julian. So you would have a full hour, and that would give you a bit longer to answer any questions that appear in the Q&A box in the course of your talk. But we also have an opportunity later on for a panel discussion after the afternoon tea break. So we'll be having that, I think, round about 10 to 3 to 3:30 at the moment, anyway. And then we'll be finishing off after the panel discussion with Sarah Pinder, one of our regulars, who'll be talking about changes to the work routes in the last few months. So, not to take up any more of your time, Julian, I'll hand over to you for your talk on asylum. Thank you very much.
Thank you very much, Richard. And what a pleasure to be back here with AstenJ and the immigration updates. I do have some slides, so I'm going to have a go at doing the screen share so that I can do those. If you're able to see them, there we go. How's that? Is that sharing okay?
That looks fine.
Brilliant. Right. All right, so this is the asylum update. It's valid as of 16th of July 2024. I can't promise that it will still be valid tomorrow because things are changing at a bit of a pace, as everybody here will be well aware. We have had not only two completely new statutes in 2022 and 2023, but also now with a change of government. It seems that the anchor is being thrown down somewhat on the plans, particularly in respect of Rwanda. So the next question is, given that those two statutes looked as though they were intended really to get everything going towards that destination of moving people on who had arrived unlawfully towards Rwanda, what happens now? So those two statutes I've just referenced, they were the Nationality, Borders and Asylum Act 2022. Key takeaways, I'm sure you will remember from previous talks on that, was the differentiation of asylum claims between people who arrive legally and those who don't. Further issues, particularly about victims of trafficking. And then the Illegal Migration Act 2023, which really consolidated and doubled down on the plans for Rwanda. Now, of course, the proposal there was that if somebody met the so-called 4 conditions, which I'll run through just for a recap in a minute, the idea was that that person who had arrived either by small boat or by lorry, or perhaps had given fraudulent details in order to gain a visit visa to which they would otherwise not have been entitled. All of those people who met those conditions could be removed, not to their home country, where they may indeed not be safe, but onto a third safe country. Now, the new Prime Minister has indicated that the Rwanda scheme will not be retained. So where are we now? What is likely to happen next? And I should say, I don't have any sort of crystal ball any more than anybody else does. So what I'm going to do is run through the parts of the IMA that are already in force and talk about how they work. And then we're going to explore a little bit what parts of the IMA and NABA are likely to survive and what parts may simply never be enforced. So as everybody here, you can't work in immigration and not have been following the Rwanda policy news for the last 3-4 years and possibly slightly longer. This has been a cornerstone of the previous government's immigration policy. It's been something that has that started off as a third country policy. And the UK is by no means alone, by the way, in trying to implement something like that. There are other European countries which are also trying to set up something similar. But of course, the new government has confirmed the Rwanda scheme will be scrapped. That comes in the wake of some court decisions in which the Secretary of State's plan to send people to Rwanda did have the brakes put on it very considerably, with a ruling that Rwanda wasn't safe enough. The government responded to that with the Safety of Rwanda Act, declaring that Rwanda was now safe. And it's perhaps best that that particular line of consideration stops there, because it's difficult to see how that could have been maintained between an executive who were insistent that Rwanda was a safe third country and a court ruling that it was not. There was no way that that could end other than with one viewpoint taking precedence over the other, or an undignified tussle. But one option is that an alternative destination could be found. Could any other third country agree to something similar? I think that's pretty unlikely, to be honest. That's partly because the Rwanda scheme was so unpopular, really, and it caused such havoc, but also just in terms of the amount of money that has already been spent on Rwanda. My prediction would be that the government would be very, very cautious over pouring further funds into any other proposed scheme. And at the other end of that scale, we've got the possibility that both acts could simply be repealed, and we could find ourselves back in the flower-filled fields of 2021, in which neither of those acts existed, and we don't have to get to grips with differentiated asylum claims or the 4 conditions. But I think that's pretty unlikely as well. I think the most likely outcome is that we keep both statutes, but it may well be that some provisions of the IMA never fully come into force. And again, that would not be particularly highly unusual. There are other acts where parts of them have never come into force. So let's have a very quick look at NABA, just in terms of a really, really useful case update there. And that case is JCK and the Secretary of State for the Home Department, Botswana 2024, UKUT 100 IAC. And this is a truly, truly helpful case, because there was obviously the discussion over NABA and whether asylum claims should be dealt with on the lower standard of proof, real risk, or whether, as NABA attempted to introduce, for those made after 28th of June 2022, whether or not it should better be the balance of probabilities. And the tribunal has determined this in very, very clear terms. Question 1 is whether on the balance of probabilities, the claimant has the characteristics, so a convention reason. So we are looking there at the balance of probabilities. So if somebody is fearing persecution for reasons of religion, is it more likely than not that they do belong to the religion that they claim? If it's political, is it more likely than not that they have that characteristic? Now, that's not necessarily the same thing as do we believe the entirety and the whole of their claim, which comes down to question 2, because it's quite possible to be a member of a religion or a political party or any other characteristic, and also to have not been entirely truthful in an application for asylum. But of course, question 1 can and should inform question 2, which is whether, again, on the balance of probabilities, is it more likely than not that they do in fact fear such persecution, the subjective fear test. Now, this is a really interesting way to look at it, because we will all have encountered, in fact, I don't know about you, but my own experience is that this seems to be more of an issue than people who actively fabricate. A bigger issue is people who do have a subjective fear. They do fear a return for good reason, but really, you know, is it really likely that this will happen again? And that's the bigger question. So this is the credibility issue. Do they in fact fear such persecution? But it's enough that they fear it. That doesn't mean it will recur or that they are right to fear it necessarily. So that third question is there, and this goes down to the lower risk of harm, the lower standard of proof, a reasonable degree of likelihood, or a real risk is how it's sometimes phrased, that there is a risk of harm, an absence of state protection, and no reasonable internal flight alternative. So those first 2 questions are on the civil standard of proof, balance of probabilities. is it more likely than not? But questions 3 to 5 are the lower standard of proof, reasonable degree of likelihood. Now that gives a really, really helpful template, both for appellant skeleton arguments and also for witness statements. So do use it. It is, I think all judges will be grateful for a witness statement and a skeleton argument that goes through those 5 questions. And even perhaps for those claims lodged prior to 28th of June 2022, it's perhaps not a bad sequential way to do things, but certainly for anything lodged after that date, going through methodically, is there a characteristic? Is there a subjective fear? All right, well, if they have the characteristic and the subjective fear, is there a real risk of that the treatment they fear will actually happen with no state protection and no internal relocation? Do bear in mind the distinction between the 2 standards of proof. It's worth reiterating, perhaps not in a witness statement, because witness statements are always a bit dubious if the appellant, who's saying he's never had education beyond the age of 13 is suddenly saying, I would like to remind the tribunal of the relevant standard of proof, and begins to sound like it's not his words. But certainly for skeletons, if you are a firm doing your own skeletons, helpful to put in the reminder that it's the lower risk of harm for those questions 3 to 5. Take the wins in refusal letters, I've put, because there has been a shocking neglect of consideration recently. And I think the problem is that some of the decision makers don't understand what it is that internal relocation means. So if we just go back slightly to questions 3 to 5, so risk of harm is fairly self-explanatory. Absence of state protection and no internal flight alternative. I've seen a lot of refusal letters recently which say, well, you can relocate anywhere that you want to relocate because you're not at risk because we don't believe you. That, of course, is not what internal flight is. If somebody is disbelieved by the tribunal, then there's no question of relocation. They don't have to relocate. Relocation is if there is a risk of harm in their home area, but they could avoid it by going somewhere else. And then the absence of state protection. I've also seen some NABA refusal letters recently, which set out, in some detail, the reasons that a person's credibility isn't accepted. And then you can almost feel the decision maker take a huge sigh of relief as they put in the standard paragraph that says, if your claim is believed, you can't seek state protection because you fear whatever which has notable power and influence, and there is no reasonable internal flight alternative, but we don't believe you, so these things don't arise. Now, that can actually be very helpful because that means that the Secretary of State has put all their eggs into one basket on credibility. And certainly with some of the NABA refusal letters, I've seen the Home Office agreeing that somebody can't seek internal flight or state relocation in cases where perhaps that's a generous interpretation. But of course, it's not our job to correct generosity. And I don't know, you don't know, whether there is some further CPIN material, for example, which actually has triggered that decision to be made. So do highlight to a judge if you need to, well, look, the Home Office say in this refusal letter that they accept the person cannot seek state protection or relocation. And then the final point on this is be careful with your dates, because there is that huge distinction between pre-28th of June 2022 and post. And it's those decisions which are coming through at the moment. Don't rely on the Home Office to have got the date right. do double check it. So what about the IMA? So here we are, back at our 4 conditions. I'm sure some of you are feeling a certain amount of déjà vu, having seen this before. But this is the centre of the IMA, and it's not yet in force. Despite not being in force, it is still relevant for some parts of the IMA that are in force. So you still need to know about them, even though the requirement that the Secretary of State must remove them is not yet there. But the 4 conditions are applicable to other elements of the Act. So here are your 4 conditions. The first is the person is here unlawfully. Now, when people hear unlawful, they often think of small boats, but it also means anybody else who should have entry clearance and doesn't. Someone who enters in breach of a deport order, don't have leave to enter, came in via deception, and so on. The entry was on or after the date on which the Act came into force. They didn't come directly to the UK, and the statute now provides that that includes passing through a third country on the way. That seems to be in direct conflict with some authorities, so there may be some tussle over that, but the statute is fairly clear. And the 4th condition, of course, is that the person requires leave to enter or remain and doesn't have it. So obviously, if somebody comes in without entry clearance after the relevant date, came via France, but actually they're here as an American visitor, so they don't require leave to enter or remain, then they are safe from the consequences of meeting those conditions. So it must be all 4 conditions that are met. So this part is not yet in force, but it's useful to just quickly recap because this was the sort of overall plan. Where the 4 conditions are met, the Secretary of State has a duty to remove an adult, but only a power to remove an unaccompanied child. That's only in specified circumstances. So, for example, where that child has an appropriate adult person who would go back with them. A duty to declare a protection or human rights claim inadmissible, which means there would be no right of appeal. Application for JR would not be suspensive, it would not suspend removal. And removal to the country of nationality, residence, embarkation, or any other to which they will be admitted, previously Rwanda. So what do we do whilst these elements are not in force? And of course, the huge problem is for those people who are stuck in limbo. It's difficult to use a neutral term, but I think it's fair to say many of them are being warehoused at the Bibi Stockholm barge or at MOD sites with just no decisions being made. Hopefully, now that it's been confirmed that Rwanda is not going ahead, those decisions will start to come in. But whilst these are not in force, there is nothing stopping the Home Office making those decisions. So although Section 2 exists and is relevant for other parts of the Act, there is nothing to stop the Secretary of State at the moment granting leave to enter to somebody who meets those 4 conditions, because Section 2 is not yet in force. However, alarm bells, be careful of Section 30, catching applicants out in future. This is a part that is already in force. It says that if somebody who has ever met the 4 conditions from, it's either June 2023 or March 2023, anybody who has ever met those 4 conditions from the introduction of the IMA can be refused entry clearance in future. So when you have one of those typical claims in which somebody has overstayed, they've formed a life here, they've met and married a spouse, they may have a child, and you're going through the pros and cons of, are you going to make an application here relying on EX1B or EX1A, or alternatively, are you going to leave the UK, prepare your application for entry clearance and come straight back? Just be very, very, very alive to the possibility that for some people, this part of the IMA will operate to prevent their re-entry. And if they are already out, that is going to be incredibly hard to overcome. So do check that when you're considering those types of applications. If they ever do come into force, the Secretary of State must make arrangements to remove them. It's interesting, I think, that it doesn't say the Secretary of State must remove them. And that may well be something that we can argue about in court proceedings whenever Section 2 does come into force. I would be prepared to argue that the issue of a relevant notice is enough for the arrangements to have been made, and the Secretary of State can then choose to exercise discretion and grant leave anyway. If Section 5 comes in, then the claim is inadmissible. But a suspensive claim can be made. So this part, I think, may well actually come into force. So Section 5 says the claim's inadmissible, but this suspensive claim can be made. The theory is that this is not an asylum or human rights claim, but it is a claim that will press pause on any removal. So let's run through what suspensive claims are. And again, bear in mind, this is all hypothetical for the future, but we do need to know about them because this is something that could be introduced fairly quickly. And of course, the suspensive claim can relate not just to Rwanda, but to a person's home country. So, I'm struggling to make that. There we go. What are suspensive claims? So there are two types: serious harm suspensive claim and removal conditions suspensive claim. A serious harm suspensive claim is one that the person would face a real risk of serious harm. Are we hearing any similarities to an asylum claim here? If removed to the country specified, such as death, torture, inhuman or degrading treatment. So in principle, if somebody comes from, say, Iraq, they've come by small boat, they meet the 4 conditions, Section 5 is introduced, their claim is inadmissible, their asylum claim cannot be considered. However, they can put in a serious harm suspensive claim, at which point the Secretary of State does have to consider this before any removal can take place. A removal condition suspensive claim is different. That's where somebody is given a notice that they meet the 4 conditions and they say, hang on, no, I don't. So my guess would be that that will principally affect surplus claimants who are in circumstances where the Home Office haven't noticed that they are surplus claimants. Key issues with the suspensive claims. Because a serious harm suspensive claim is not a human rights claim, there is no right to appeal, although there may be an application available to the upper tribunal, which will operate in a similar way to a judicial review. I don't see how that is sustainable, because we have a whole line of case law, Crown on the application of AT, by Hinga, Aligambari. What is a human rights claim? And a human rights claim is a claim in which an applicant raises human rights and it's not fanciful. So I cannot see a situation in which somebody's saying that removal would cause them death or serious harm or inhuman and degrading treatment could conceivably be considered anything other than a human rights claim. So it may well be that a right of appeal simply has to be reintroduced in some fashion for those. Other issues, this is a really interesting one. The Secretary of State must take into account any assurances given by the receiving state's government. Now, in extradition claims, you will quite frequently see an assurance be given by a receiving state. So they say, we want Joe Bloggs back because we want him to serve a sentence that he skipped out on, or he absented himself from his trial and was convicted in absence, and we want him back to serve 5 years. And we say, well, hang on a moment, you can only do that if you promise not to put him in XYZ institution, because those don't have adequate cell space, or they don't have adequate ventilation, or whatever it might be. And the receiving state writes back and says, yes, okay, we can do that. In fact, rather rather sadly, I think that at least for some period of time, the UK was being obliged to offer an assurance in respect of one of the prisons in the UK. Now that indicates that a receiving state of a failed asylum seeker or a prospective asylum seeker, a receiving state could be approached for an assurance. It would obviously have to not be, as an extradition claim is, where the person is named, but we could, it may well be that assurances are given in future that returnees from the UK will not have their mobile phone data considered. I can't, off the top of my head, what other things could we have? Will not be incarcerated in certain institutions, will not be prosecuted for absenting themselves from a request for military service, things of that nature. So that's quite interesting in terms of prospective returns. But these serious harm suspensive claims are ones where everybody has to get their skates on. The time limits are incredibly rigorous. 8 days to get your application in, 4 days for the response. The requirements are compelling evidence on a prescribed form with prescribed information. I mean, it's clearly going to be difficult for people to get that type of compelling evidence together in 8 days. So as soon as somebody walks through the door, they need to start preparing their case, because when the Secretary of State triggers Section 5 and says, your claim is inadmissible, from the moment you have that inadmissibility decision, you've got a very, very brief window to get this done and in. And the Secretary of State may certify a suspensive claim as clearly unfounded. That would obviously have to be on the same or on a similar basis to our current clearly unfounded case law, so bound to fail. If it's not certified as clearly unfounded, then there is a right of appeal to the upper tribunal. If it is clearly unfounded, you can't appeal, but you can apply to the upper tribunal for permission to appeal the certificate. There's no onwards right of appeal to the Court of Appeal, but the upper tribunal can also grant or refuse an application to bring a suspensive claim outside the 8-day period, or to grant or refuse permission to rely on new matters. I have to say, having specialist upper tribunal judges spending their days considering whether or not to grant an application to let in a claim after 9 days instead of 8, perhaps might not be the very, very best use of time, but it may well be that there are court staff who can act as legal officers to look at those. So detention and bail. powers of detention, this is a power to detain where either an immigration officer or the Secretary of State suspects the person meets the 4 conditions, pending a decision as to whether those conditions are met. So you're here, we think you probably meet the 4 conditions, we can detain you until we know. Where they suspect the Secretary of State has a duty to make arrangements for the removal. Now, obviously, Section 2 is not currently in force, but if it ever comes in, then that as well. And if there is such a duty, then pending removal. And the period of detention, this is in force. It amends all sorts of different provisions in all sorts of different statutes, so that a person liable to be detained may be detained, and this is sort of, imagine it being in bold and bright red, for such period as, in the opinion of the Secretary of State, is reasonably necessary to examine whatever is being done to be done. Now, the period in the opinion of the Secretary of State is likely to be longer than the period that's reasonable in the opinion of the applicant. But there will at some point be considered to be a limit at which it's no longer necessary and it's completely unreasonable. So the next part is that this applies regardless of whether there is anything that for the time being prevents the examination or removal from being carried out, the decision from being made, or the directions from being given. Perhaps it's me, but I don't understand how you can have a reasonably necessary period that is also ongoing, regardless of whether it is impossible to do it. Those 2 things seem to be in obvious conflict, and I'm sure that there will be cases about them. There are, of course, some limitations, particularly in respect of pregnant women and unaccompanied children. A big one on electronic devices, it is in force. So those liable to be detained under paragraph 16 2C of Schedule 2 of the 1971 Act may be searched for things on which certain information is or may be stored in electronic form. Basically, mobile phones, iPads, things like that. It only applies to people who are liable to be detained under paragraph 16 2C. And that is not yet in force because that's introduced by Section 11. So although Section 15 is in force, in that those liable to be detained under paragraph 16 2C may be searched. At present, nobody is being detained under paragraph 16 2C, but a really big one to be aware of for the future, because it will be, I suspect, very, very easy for somebody to be detained under paragraph 16 2 rather than 2C, and for immigration officers to think they have a power to search when they don't. So do look out for those. So we now move on to unaccompanied children. The accommodation provisions are set out at sections 16 to 21. This allows the Secretary of State to provide accommodation for unaccompanied children, which the hope is will ease the burden on local authorities because it can be provided by the Secretary of State. But Section 17 allows the Secretary of State to cease the provision and to transfer the child back to the local authority under Section 20 of the Children Act. That's sort of voluntary care. So the Secretary of State would agree that the child should go into the local authority's care, or to cease local authority accommodation and to transfer the child to Section 16 accommodation instead. And then Section 18 allows the Secretary of State to direct the local authority to provide information to inform the Section 17 decision. Now, of course, you may well have children who are so traumatized from the journey that they've made or from what they have been through, that really the Section 16 accommodation is inadequate, and they're going to need specialised foster care, for example. Or you may have a child who is out of control. What, if they were with their parents, would be called beyond parental control. Again, that child might need specialist accommodation in a local authority children's home. They might have other options. They might have somebody who's a distant relative, where the Secretary of State, the local authority would support a kinship care arrangement, special guardianship order. So there is that flexibility there. But it does seem that there are going to be immigration service run children's homes. So that is something that I'm sure will be monitored by various NGOs. Modern slavery is a huge one under both acts. So Section 22 of the IMA removes the provisions that were placed it within NABA, which is the recovery period for victims of trafficking, or a requirement to grant leave to remain. So this is, if somebody meets the 4 conditions, they don't need or they won't be given a recovery period. Again, we may find that that is not congruent with the various anti-trafficking treaties. There is an exception where a person can remain if they're cooperating with an investigation, or if there's criminal proceedings and they need to be here, and there's no counterbalancing weight of harm. And then Section 23 removes the Modern Slavery Act 2015 duty, which requires that assistance and support are given where the person meets the 4 conditions. So again, it's scaling back the support for people who are victims of modern slavery. Now, age assessments are quite a key issue at the moment. There are quite a few people with age assessment difficulties. Again, not yet in force, but be aware that if a person who meets the 4 conditions, a local authority can decide their age and there won't be a right of appeal. An application for JR can be brought, but it won't be suspensive. And a rather strange provision that the court or tribunal may only grant relief if the decision was wrong in law and not if it was wrong in fact. Now, in reality, if a decision is completely wrong in fact, then it's likely that a legal error has been made along the way. And if a court on judicial review establishes that there has been an error of fact, that egregious, it may, on a public law basis, amount in any event to an error of law. And then finally, we've got this concept of a specified scientific method of age assessment. Doctors are quite dubious about this and how reliable it really is. But there is a provision in there that says that if a person refuses to cooperate with modern scientific methods of age assessment, then the Secretary of State can simply treat them as being over 18. Safe states and legal routes, I've put this in because it's in force. It used to be that an asylum claim was inadmissible if made by a national of a safe state. It's now asylum or human rights claim, unless there's exceptional circumstances. And those exceptional circumstances are envisaged where a state is derogating under Article 15, or where Article 7.1 TEU is being proposed or upheld. Now, that is a near impossible test to meet because very few states will derogate under Article 15 ECHR, and Article 7.1 of the TEU is where I think it needs 2/3 of the member states to vote to say that one of the member states of the European Union is behaving terribly badly, and therefore triggering this process should be proposed. Where it has been proposed, and I think it's been proposed once in Poland or about Poland in respect of the independence of their judges, and once in respect of Hungary, and both are trickling on with no actual action. So it's quite difficult to establish that. However, this is those are examples given. It's not an exclusive list. So it would be possible to formulate an argument that were X state a member of the European Union, the behaviour of that state is such as it would trigger an Article 7.1 being proposed, and approaching it by way of analogy rather than anything else. It would be clumsy, but potentially arguable. And then legal routes. Again, this is in force. Requires the Secretary of State to specify the maximum number of people who can enter, and to explain why, if there are more than is the maximum, and also to prepare and publish a report on safe and legal routes. It was due 20th of January 2024. I think it may have been slightly late. It wasn't particularly anything that wasn't already known. It essentially said there aren't any. We have the ARAP programme and similar for Afghanistan, the Ukraine scheme, and that's it. Credibility, also relevant here. It amends our old friend Section 8 of the 2004 Act, and it expands on it to include failing to produce or destroying an identity document. The interesting thing there is not the failing to produce or destroying an identity document, which has always been a Section 8 credibility issue. It is the definition of identity document that's interesting, because an identity document is now information stored in electronic form on a thing that was found on the claimant or appears to have been in possession of the claimant. And it includes anything that seems reasonably likely to have information about the person's identity. So in theory, your Google Maps history or your Facebook account would both count as an identity document. So failing to hand over your phone or the PIN for that phone would count there. That's the end of the update for now. I can see we do have one Q&A. Let me just stop sharing my screen. Not sure that I've managed to stop sharing it. Let's try that again. Yep, there we go. All right, so I've got a question there. Does the two-tier standard of proof apply to fresh claims made after the 28th of June, where the original claims were made before and refused prior to the 28th of June? And yes, I think that they would. A fresh claim is still a claim under NABA. So although 353 criteria, I'm just going to bring up on my own screen the Nationality and Borders Act to see if there's anything in there that would suggest anything different. But I don't think that that would be the case. it's something that might be worth looking into in more detail if somebody was in that situation. But as far as I can see it, that just at a glance, a fresh claim would trigger the new dates in the same way as a fresh claim under the immigration rules in any other situation would do the same. So are there any other questions anybody has? I think I have possibly just sent everybody to sleep with
I
the
think you
Illegal
must have
Migration
actually,
Act.
you must have actually explained everything so well that no questions can arise
Or
after your
possibly
thorough
that.
explanation. Well, Julian, I think we may be able to begin our tea break this afternoon, just a wee bit earlier than we're down for. It actually says in the revised program that we were going to finish your talk at 2:35, and in fact it's getting on for that, just a few minutes away. So we're down then for a tea break until 10 minutes to 3. So why don't we have our tea break now, and then there'll be a panel discussion at as I say 10 to 3. And you'll be on the panel yourself, Julian, won't you?
I will. Yes, I
Great.
am.
So we'll see you then, and everybody else hope to see you for that panel discussion. And anything that we weren't able to get round to earlier on, those questions can be brought up again, and hopefully we can discuss them. So see you shortly. Bye-bye for now. I think we're ready now to start with the panel discussion. And here's Julian. You haven't got very far, Julian. Welcome back. And I wonder, do we have Samina? Is she available? Now, I can let you know that Sarah Pinder, who was due to finish off our webinar after the panel discussion, may be held up in court, in which case Samina will be taking over her talk. They're close colleagues and both barristers at the same chambers, so Samina can take over from Sarah if necessary. And I see from the webinar chat that you've been assured that everyone will still get 6 CPD hours, even though one of our speakers was unable to attend today. And our remaining speakers, currently 2 of us, will be ready to take on any additional questions from the attendees. Well, I think now would be the time for us to take a look at the Q&A box at the bottom of our screen and see
Richard,
what...
could I jump in on
Oh,
the
please.
question that I did answer just before the break, because I think I can now give a much fuller and more complete answer, having been back
Okay.
to check. I didn't want to say anything that was that I wasn't certain of. But when we go and look at the legislation, we've got 2 slightly different questions in one question here. So the question is, does the 2-tier standard of proof apply to fresh claims made after June 2022 if the original claim was made before and refused prior to 28th of June 2022? So, for example, you have somebody who comes in 2021, claims asylum, is refused, realises that what they needed was more evidence, goes away and gets it, and puts in their fresh claim. The 2-tier element of it is probably which is in section 12. This is the differential treatment of refugees. And what it does is it breaks down applicants into group 1 refugees and group 2 refugees. And if you're a group 1 refugee, then you've come directly to the UK from a country or territory where your life or freedom was threatened and presented without delay to the authorities. And if they are here unlawfully, the additional requirement is they can show good cause, although really your good cause is going to be, I fear persecution. Now, that's not a different standard of proof, the differential treatment, it's a differential outcome. So the outcome is that a group 1 refugee may be given a more generous period of leave to enter or remain, may have different requirements to get indefinite leave to remain, and may be entitled to better family reunion provisions than a group 2 refugee. Now, if the fresh claim relies on a factual matrix, so the same facts as the first claim, then I think it is arguable that they are a group 1 refugee regardless, because their entry and the facts of their claim predate this application. And if it relies on things that post-date that part, then they clearly have come to the UK directly from a country where their life or freedom was threatened, because they're a surplus refugee. You know, if they made a political claim before, they've now converted their religion, they haven't gone anywhere at the point where their life and liberty was threatened, because they claimed right here, right now. And so I think that there is good argument that fresh claimants fall to be treated as group 1 refugees. In terms of the new 2-tier standard of proof, that comes from section 30 to 37, and that, I'm afraid, is absolutely crystal clear. These provisions apply in relation to a determination where the claim was made on or after the day this section comes into force, and includes a claim in any form or to any person which falls to be determined. So it definitely involves a fresh claim. So the good news is your fresh claimant might be a group 1 refugee and entitled to a more generous period of leave if leave is granted. The bad news is that they still have to meet the two-part standard of proof. So I hope that's a slightly fuller question, fuller answer.
Right. Well, I think we could maybe at this stage have a look at what's in the Q&A box. We've got 25 questions now, apparently, so let's just have a look. Perhaps starting at the... Let's start at what is the bottom, shall we? And that way we won't be going over things that we've already dealt with. Well, what I've got at the bottom of my list is 5 years continuous EEA residence able to be satisfied if it is broken by a prison sentence? The client has achieved 5+ years before and after the custodial sentence, but not 5 years continuous. Oh, yes, I see what's meant. The client has been in the UK for more than 5 years, but that's been interrupted by a prison sentence. Well, if you haven't already got 5 years continuous residence before you go to prison, you're at the bottom end of the scale, aren't you, for what's it called? The deportation or removal is subject only to matters of public policy or public security. If you've got less than 5 years, if it's after 5 years, it's serious grounds of public policy or public security. So yeah, of course, this isn't removal. It's whether you're eligible for for 5 years continuous residence? Well, to cut a long story short, I would say no. Oh, Samina, you're back. So nice to see you. Sorry we started without you. So does a prison sentence for somebody who is an EEA national break up a 5-year period of continuous residence?
I think it's the classic lawyer's answer, isn't it? It depends. It's Secretary of State and Romero, which is a preliminary ruling from the European Court of Human Rights. The acquisition of permanent residence is necessary to qualify for the enhanced protection. Imprisonment allows doubt to be cast on integrative links, but shouldn't be excluded from the calculation. So if you've got, if you're counting your 5 years and it's interrupted by a 3-month prison sentence, your integrative links are probably not broken. But if you've been in the UK for 5 years and 4.5 of them were in custody, then they probably are.
Yes, we don't know what years the person is talking about. Continuous EEA residence, was this under the EEA regulations before the end of 2020? We don't actually know what the period is that the questioner is referring to. Does it matter? Well, maybe she can.
I don't think it necessarily matters. I'm going to put some helpful cases into the reply on the chat to see if that
is that Vomero and a few others. I think there's
yes. So I see. Oh, that's sent it into the answered column. Sorry. So if you want to find it, it's now in the answer column. And then the other case was Hussein, the Supreme Court decision in 2022.
Oh, thanks, Julian. Oh, I see another question has arrived at the bottom of our list here. First of all, we've got from Rajinder about that previous question. Yes, the period was before 2020 under the EEA regulations. 5 years residence interrupted by a term in prison. But as you say, Julian, you've sent into the answer box some useful cases. So just above that, we've got an anonymous attendee who asks, can a pre-settled status be extended if there are more than allowed absences in the last 5 years to meet the settled status requirement?
I think that one's also, you'll have to really look at what the allowed absences are, and what are the reasons for the absences, because it may well be that those absences are exceptions or accepted to the absences, so it doesn't exceed what the absences should be, if that makes sense. So the guidance is really helpful in relation to this. It's quite extensive, but you've got COVID-related absences which may not have been COVID-related, but the second absence may be COVID-related, and it may have extended for a period of over 12 months for important reasons not connected to COVID. So whatever the case is, I think with absences like that, you need to collate as much information as you can, and against the absences, find out what the reasons are for those absences. If you can get evidence for that, then you can certainly put all of that in against the absences. I had a case where he had several different absences. One was a holiday, one was a COVID related, and one, his parents had become ill with COVID while he was still in Spain. So along the way, he was able to explain each of them with medical records and so on. Still refused at application stage, but when you get on at appeal stage, and if you can cross-refer it to the guidance, then it should allow you to move forward with a further application. You might even be granted a further pre-settled status period for 5 years.
Oh, thanks very much. That's very helpful, Samina. Now, above that, we have a question from Regina. What is the financial requirement for the parent of a British child on the 5-year route to settlement? I think it's simply adequate maintenance and accommodation, isn't it? There isn't a specific figure like £29,000. I think it's just adequate maintenance. So, okay, there isn't any particular figure. Now, above Regina, we have, let's see, if the main skilled worker is dead, what would happen to his or her PBS dependents? Can they stay until the expiry of their visa? And what if they wish to go to their home country for the funeral? Then the dependent husband and son can return to the UK without any hassle. Okay, so the skilled worker who is the main person has died. There are now the bereaved husband and son who have, I guess, leave to remain in line with their sponsor. And can they stay now, despite the demise of their sponsor? And can they go home for the funeral and come back within the terms of their current leave to remain? Well, I don't think the death of the sponsor automatically brings their own leave to remain to an end.
Because I don't think it automatically does, but I think they would have to, because they are the dependents, if I've understood it right. They would have to do something to regularize.
Yes, I think probably if they came back from abroad, unless they said nothing about the fact that their sponsor has died, I don't know, they might just be waved through if it's clear that they have still existing leave in their passports or their biometric residence card, I suppose. They might be asked, of course, if everything is still the same as it was before. And then if they say that nothing's changed, that would be gaining entry by deception if they don't admit that their sponsor has died.
Yeah.
I think that they would technically lose their right to be here, because their right to be here is tied to the skilled worker. And if they, in the same way that if the skilled worker left simply because they had a different or a better job elsewhere, the dependents wouldn't be able to stay. I think that if a dependent, if the sponsor sadly dies, the dependents also lose their leave. But like Richard says, they would, I think, be waved through. And the difficulty would come if they were actually asked. And of course, in situations where somebody's been recently bereaved, they're going to struggle with answering those questions. And if they do so untruthfully, then that creates a whole new can of worms and potentially an immigration offence. I think what they would need to do would be to put in an application for leave outside the rules on the basis of Article 8, saying exceptional circumstances, please can we stay to the expiry of the visa, in order to, because there will be all sorts of things that they'll need to do. They'll need to sort out the end of their rent on their home or potentially sell a house if they're on a mortgage situation. They might be a person where the child has been here 7 years, in which case they've got that application to put in. That doesn't help with what happens over the funeral, which of course would take place sooner. So they could, depending on the relationship that the solicitor has with the Home Office, there are some firms which might be able to get that expedited, but they're very, very few and far between. So it's a terrible situation for that family to be in. They may either need to leave and then, if questioned when they return, explain that they need an extension of their existing leave to enter just to the end of what would have been the expiry of the visa period, in order to make the arrangements that they need to make. But I would be very cautious about leaving, coming back, and just assuming that no questions would be asked.
Yes. Oh, that sounds very sensible, Julian. It may be worth emphasizing that when these questions appear, obviously not all the details can be given. It would take far too long. So our answers shouldn't be taken as gospel, because we don't know the full circumstances, and there might be missing information which would put a different complexion on our answers if we had that information. So be sure and go to a qualified lawyer to follow this up if you're going to be acting upon it, to make sure that that person has the full story and not just the bare bones.
I've just seen Andrew Frost has commented that they would have a duty to inform the Home Office, irrespective of whether they're seeking to leave and re-enter. And I suppose I think that sounds right. There is a duty to inform, especially in relation to a change of circumstance. And there used to be, I don't know if anyone remembers about it used to be a general ground of refusal if you hadn't informed about your change of circumstance. I can't remember if anyone remembers that, Richard or Julian.
Oh, that does sound right.
Does
Yes.
ring a bell, doesn't it?
Yes.
There was an actual suitability. I'll have a quick look, but if I remember correctly.
And I think Aisha's made a very good point in the comments as well. The employer will be updating their system, informing the Home Office that their foreign employee has passed away.
Oh, of course.
With the consequent effect on the dependent visa. So again,
Yes.
hoping for the best, I think it would be a bit of an ostrich approach, put your head in the sand and hope for the best. I think would cause all sorts of future difficulties.
Yes, actually, that's a very good point, that the sponsoring employer would have a duty to inform the Home Office that the person to whom they'd issued the certificate of sponsorship is no longer working for them because he's departed this life. And better to inform the Home Office yourself sooner than wait for the employer to do that.
So I have found it. So one of the grounds is where's it gone? I think it's under part 9. Change of circumstances 9.20.1, I think it is. That's worth looking at. Let me have a look and see if I can find it. Entry clearance or permission held by a person may be cancelled where there has been a change in circumstances since the entry clearance or permission was granted, that it should be cancelled. So no, that's not clear. It's not the one I was looking for, but they've got the power to cancel it. But if you inform them, it doesn't mean they necessarily would. Like Julian said, they may well allow you to continue and to resolve those matters that need resolving.
Oh, thank you very much. Oh, now at the very bottom, there's a question from Samsung, not the Korean company, I take it. Under the new rule, how long are the dependents of work permit holders stay? out of the UK continuously within 3 years or next extension. I'm not quite sure I get this. What's the new rule? Under the new rule, how long are the dependents of a work permit holder? I think it is allowed to stay out of the UK continuously within 3 years. Oh, you mean that the work permit holder has got permission for 3 years?
Yeah.
And would the next extension be for 2 years to make up 5 years? I think we would need more information to answer this question. Oh, yes, actually, here there's more stuff, including from Aisha, who's asked us questions before. Yes, don't forget that the employer will be updating their SMS system. Yep, that's it. Oh, now we have a question from Umberto Ferrarini. Question related to skilled work visa application. The applicant has completed the application and selected the box that her salary is on the immigration salary list, which was not the case. However, the salary in the certificate of sponsorship meets the requirements on the SOC code. Oh, something occupation code, yeah. Salary. The applicant has not yet submitted her biometrics. The salary is on the immigration salary list. I'm not quite sure what that means. I mean, there are different salaries for different situations for skilled workers. I mean, that's something that would be discussed in Sarah's talk coming after this.
So I'm wondering whether that question or the question being asked there is that there's a minor error in terms of everything's correct. They meet the salary codes and so on, but in the tick box application form, someone's mixed up and ticked the wrong box, and you later want to just put in a further letter to say, oh, we ticked the wrong box, but this is the correct code, everything's correct. I mean, I think if that is the case, I don't think you need to. It's a procedural point. I don't think you would, as long as you're making the correction, that you would need to make a full new application form, unless you're very early on in application stage. This is if I've got it correct. If you're very early on in the application stage, why not make the full new application, and that just takes away from it. But if it is the case that you've made the mistake and it needs to be corrected, you have to let them know, and sooner rather than later, because if you leave it till later, they may well raise that as an issue and refusing it to say that you hadn't raised it at the earliest possible time.
Yes. Yeah,
I
I
don't
think
know whether anyone else has read it the same way I've read it.
Oh, maybe I haven't scrolled down far enough.
No,
Sorry.
I think
There
I
is
agree.
more for the
It's
same
about
question. Yeah. Is it
can
possible?
we correct a trivial error on a further covering letter, or do we have to withdraw and reapply? I mean, I'm always overcautious in these scenarios, because you can draft the most beautiful covering letter that would make the angels weep, and if it doesn't get read, it won't help. Again, I think if you've got a named contact with a personal email address that you can just email the caseworker and say, look, we've made a slight error, can you accept this as an amendment? That's one thing. But if it's going to a generic box, that's perhaps another.
Oh, right. Well, Umberto did actually, yeah, did provide lots more information. Sorry, I missed that myself. Now, we've got under that a question from Mohammed Emanul Haq. Applicant has been in the UK continuously for 14 years, but no pre-settled status, but partner has given him divorce. He applied for a retained right of residency. Okay, but what is the question? Is he going to get, or does he have a retained right of residence or not?
So he's saying, can he apply for a retained right if no pre-settled status? I think there's a couple of, if you continue to scroll down, I think there's a few more. I think he's finished the question there.
Ah,
Yeah. I suppose it depends whether he has, if he had status under the regulations before. So he doesn't have settled status under the EU scheme, but did he have status under the EA regulations first? And then if he was, yeah, I think that's what he'd need. But I'm not sure if he or her, she would need a relevant document before applying for settled status anyway. So you need to look at the definition, and I can quickly have a look, but I think the first thing first is to see whether they had any kind of status under the regulations.
yes. Yes, if he didn't have status under the regulations, then there mightn't be much hope of getting pre-settled status now.
If he's been here unlawfully for 14 years and didn't get pre-settled status back in 2020, is that because he was ineligible for pre-settled status because the relationship hadn't been durable? Because if the relationship wasn't durable or they weren't married at the relevant date, because you either need to have been married prior to the relevant date or durable with a subsequent marriage, and she's now divorced him, then I think that is, I don't like to use the phrase hopeless case, but not an appealing one, if I put it that way. So it's very much going to depend on, was he a durable partner for 14, 12 of those 14 years? Then they married and now she's divorced him, for whatever reason. Or did the marriage and the relationship post-date the relevant date?
Ah, right. Well, now I'm just scrolling up again a wee bit, and then from Samsung we have the response, yes, can stay out of UK. What was the original question from Samsung? Oh, must be quite a long way up. I've forgotten what it is now. But anyway, that's what Samsung now says.
He says, under the new rule, how long are the dependents of work permit holders staying out of the UK continuously within the 3 years or next extension? And then the bit that he's asked, yes, can stay out of the UK. I'm not sure that still makes sense at the minute.
Yes. Oh dear, I think we'll need more information. Shall we go on to the one underneath that? A skilled worker, minister of religion, could not find his relevant occupational code on the visa application form while it appears on the COS. What do we do? I mean, would the visa application form have preordained occupation codes that you have to, that if it's not pre-printed on the form, you can't insert a code of your own? I'm afraid I don't know the answer. Do you have a menu of well, what's it called? Something
codes.
occupational codes. Standard occupational codes. Do you have a menu of those on the application form and you have to select one?
I think that you can query if it's not your, if you feel that the standard occupational code is missing, then query it
Hmm.
with someone.
Hmm. Yeah, the question looks like he was expecting to find a list of occupational codes, one of which he could select on the visa application form. But I don't think there is such a pre-printed list already on the form before you start filling it in. Or have I got that wrong?
I'm actually not sure about what the forms.
Yeah, I mean, there are so many different codes. They could hardly all be printed on the form for you to select on the
think
visa application form itself.
Yeah, you're right. You would put the code in yourself, wouldn't you?
Yes, yes, you would, wouldn't you? Yeah. I mean, you would have to look it up. I mean, it's very long in the immigration rules, the standard occupational codes in the appendix. You'd simply have to find it, or your employer would have to find it, and then you would put that in the application form. While it appears on the COS, well, I mean, if the employer has already put it in on the COS, could you not put it in yourself on your application form? Put in the same one? Unless you think the employer has made a mistake and that code does not apply to you. Yeah, I think we can't really go beyond that, can we? Hmm.
There's a question for you, I think, Richard. It's from Mahinda. It's about student, if a student, can you see that one?
Oh, is it further on down?
Yeah.
Mahinda. Oh,
It says if a student makes an in-country marriage
oh,
application.
yes, I've got it. Yes,
Yeah.
thank you. If a student makes an in-country marriage application well before his student visa is due to expire, and if that marriage application is refused while he is still within the validity of a student visa, will the refusal attract a right of appeal? His student visa is not curtailed. Well, I think you're entitled to appeal on human rights grounds against the refusal of a marriage, of the refusal of leave to remain on the basis of marriage, even though you've still got leave in another capacity. I think that's right.
I think that you can, but you will almost inevitably be dismissed because there is no impact on your human rights, on your family life.
Oh, you're not going, yes, you're not in
You're not going
need of
anywhere.
removal.
However, if you just wanted to secure the judicial nod of approval for the fact that your marriage is genuine, if that's the problem, it's a high risk strategy, but it's one that you could do. But I think if you've got leave to remain, more sensible to reapply with whatever was missing from the first one.
Yes. Yes. I'm sure. Yeah, that sounds absolutely right. Yeah, thank you. Oh, now we've got something here about the COS. 2463 was used in the certificate of sponsorship, which does not appear on the drop-down list of the application. Oh, so there's a drop-down list on the application form. It must be a very long list. Okay, what do you do? I think then you have to get in touch with your sponsoring employer and say that the code that he's selected isn't one that appears, or it isn't one that's used for an application like this one. Hmm. So, I mean, you'd have to sort that out with the employer, wouldn't you? The employer might have got it wrong.
Yeah, it sounds like someone's got it wrong, and you need to, cross-refer and make those queries, really.
Yes. Oh, well, you just have to check, don't you? Anyway, on an appendix, standard occupational codes, what
Yeah.
does the code 2463 represent? What's the job? And if it's not the job that the employee is supposed to be doing, then the employer would have to, I suppose, issue a fresh certificate of sponsorship.
2463 is clergy, I think. So I wonder whether
Oh, was this the Tier 2 Minister of Religion?
Tier 2 Minister of Religion
Ah,
question. In which case that is, I think, surely the correct code. Chaplain, clergyman, minister of religion.
yes.
I suppose it depends what exactly they are, if they're a friar or if they're a, if there's some other sort of subsidiary clergy title that they use. But otherwise, I think you've got to just use 2463 as a catch-all if it's clergy.
Yes.
Oh, I see. There's a follow-up there. 2463 is the code for clergy, minister of religion. However, it doesn't appear on the application form.
Well, does it have to appear? Could you explain what you mean by appear on the application form? You mentioned a drop-down list. You mean?
I'm kind of thinking, is it when you I suppose it's because none of us kind of look at application forms really, but when you look at the application form and you have to pick which one you are, it brings a list of different things which you can pick. But you're saying the one for the clergy doesn't appear on that drop down list. I think then that maybe that's not. I think you'd have to check that with the whoever you submit the application to, and make that query, because if it's an error, then that needs to be corrected on the form on their end.
Yeah. I mean, I wonder if it's even the right form, because if the application is for a minister of religion and the occupation code for that isn't on the list, maybe it's not the right form for a minister of religion.
Yeah, it actually could be that it's not the right form.
Oh dear.
A little rabbit hole.
Yes, indeed. Oh dear.
I do enjoy the niche questions we get into ministers of religion and what happens if a sponsor dies.
Yes.
But we
Not
do
everyday problems that come our way, indeed.
we do have one that's hopefully straightforward, I can see, from Tajamal Bhatt. What's the best and safest option for an EEA national currently living abroad to be reunited with her British spouse? Is entry clearance under Appendix FM still a better option, or can she enter the UK and make an in-country spouse application instead? I would say entry clearance 100%, otherwise you've got EX1B, and whether or not there's insurmountable obstacles to living elsewhere in Europe.
Yes.
Unless they've lived together outside in a EU country prior to 2020, then the surrender Singh route is possibly open to them. But it all depends on whether you've lived outside the United Kingdom together in an EU, you've exercised treaty rights, possibly.
Actually, has the surrender Singh route now closed altogether?
There was going to be that, actually. I haven't checked lately, but yeah.
I think it has. Yeah, I think it's finally closed. So that would leave ordinary entry clearance under Appendix FM.
There was another question there from Wei Ling, I think, which is again an EUSS question. So that's an interesting one as well. I have a client who has EUSS settled status but divorced from her sponsor. would she be eligible to sponsor her minor child from a non-EU country to join her in the UK where she has settled status through retained right route? I think you have to look at GEN 1.2. And if she has, and I can check now, but she has settled status, usually it's the EEA national with settled status who would be in scope to sponsor their child. I wonder actually whether there's an EU route for this child. They would have to, depends how old they are and if they're able, so this, you're saying it's a minor child.
Yes. If she were still married to an EU citizen and they both have settled status, well, both her children from somebody else, well, yes, if she was still married, she could sponsor her own child. If the child, particularly if the child was born before the end of 2020, but now that she's divorced, can she sponsor her own child? Yeah.
It would have to be under Appendix
retained driver
FM.
residence, yeah.
Would it be under Appendix FM? And GEN, so GEN 1.2 says, let me just see. Yeah, so references to a person in the UK with limited leave under Appendix EU, if they were making an Appendix FM application, means an EA national in the UK who holds valid limited leave to enter with reference to these rules. So if they wanted to make an Appendix FM application, I don't think they would be in a position to, because they're not the EA national.
Oh, and that's right. But in fact, she's got settled status rather than pre-settled status. But
so that's
can you
akin to indefinite leave to remain, isn't it? So I don't see why she couldn't make an Appendix FM application.
Oh, yes, because she's got indefinite leave anyway. Yes.
Yeah.
Yes. Yeah, that's right. But it wouldn't be through the EU settlement scheme free of charge. She'd have to pay the application fee. Yes. So unfortunately, that may well be the case. Now I wonder if we actually shouldn't be drawing the panel discussion to an end, because we've still got to get through the next talk, which I think, Samina, you'll be giving.
I will be.
Because it looks as if Sarah won't be able to join us.
I'm just getting a message through from her, so hopefully let's see what that says. But
Okay.
She may join us halfway through. No, she's not going to be able to join us. Yeah, so I thought she might be able to join us halfway through, but she won't today. So I am going to cover, but what I am covering for her will be slightly a whistle-stop tour of that topic, given I am covering. But happy if you wanted to answer some more questions before I go on to.
Well, I was just wondering, we've got the full course notes and slides anyway from Sarah. There are an awful lot of questions still out there.
Yeah.
If we perhaps just carry on with the question and answer session for the time being, and if Julian is okay with that.
Yeah. Is that in lieu? Will that be in lieu of the?
In lieu of doing, in lieu of Samina doing that talk.
Yeah, happy to do that.
Because the participants will have all the course notes and slides from Sarah anyway. And it may be that there are so many people with questions for us that we could just carry on with those for the time being.
That's fine. Happy to do that. So looking at Tajamal, he's come back on the scenario that he gave, and he said in the above scenario, would that EA national be able to sponsor her non-EA parent from abroad after getting spouse entry clearance? Non-EA. That's a complicated question, because you're saying that after getting spouse entry clearance, but they've already got leave as an
Well, an EEA national who's got status under the settlement scheme would be able to sponsor a non-EEA parent as a joining family member.
yeah.
Hmm.
And that would be subject to dependency, right? At this stage.
Oh, yes, that's right. Well, the EEA national has got spouse entry clearance. Oh, so she's not here under the settlement scheme. Is that right? I
So
mean,
that's the bit that's confusing.
yeah, because
Yeah.
yes, the EEA national could be someone who never resided in the UK before.
I suppose I'm now speculating, but if the spouse was the original spouse was an EA national, the marriage took place, after 2020, it may be that's why she's been granted entry clearance as a spouse.
Mm-hmm. Yes.
Then,
Oh, so she may be here under the under Appendix FM?
yeah.
Mm-hmm. Okay. Oh, well, if that's the case, if she's here under Appendix FM, then her mother or parent would have to come in under Appendix adult dependent relative, I suppose.
Yeah, I think that's right. Adult dependent relative.
Mm-hmm.
Which is a really high threshold to.
Oh, yes, it is a very high
to be.
threshold to meet. Mm-hmm. Yes.
Just
So,
going backwards, I suppose there's a question from TMC solicitors. It's about the university curtailing the student leave due to some reason. Following the receipt of curtailment notice, the student received an offer from another institution. He accepted the offer, paid the fees. The university took some time to assign the CAS. The potential student has now filed the fee waiver application to gain some time. Now that he has received the CAS, what should he do to apply for the student fee visa, as the fee waiver is non-withdrawable? I don't think the fee waiver would ever stop time, would it? That doesn't stop time. It doesn't stop the time period in which you're entitled to put in the application. They would have given him 60 days, I would think.
Well, you have to apply for a fee waiver before you make the application, which is to be covered by the fee waiver. So once the fee waiver is granted, you can go ahead and make the application. So if he's now received a confirmation of acceptance for studies, he can apply for a student visa, can't he? Using that fee waiver, because it's been granted.
I don't think the fee waiver has been granted, no. It's just potentially the application is pending.
Oh, yes, sorry. So the application for a fee waiver is non-withdrawable. Really?
Yeah.
Okay.
But so what they're saying is that the CAS, they were waiting for the CAS, so to buy time, they put in a fee waiver application. does a fee waiver application stop time from running? I wasn't quite
Well,
clear that.
I don't think it stops time from running. I mean, oh, in the sense that if you apply for a fee waiver and your current leave is going to expire fairly soon, the fee waiver stops the time from running. So you've got until whenever you get the decision on the application for a fee waiver. So your leave won't expire before your application for a fee waiver is decided. Is that the situation? So there's no concerns about your leave to remain running out, and then you get the fee waiver granted, but by then you've become an overstayer, which might have repercussions further down the line. Because I think the application for a fee waiver, the time spent on that is not one of the situations covered by paragraph 39E, where it's disregarded when it comes to, 10-year long residence.
That's what, yeah, I thought that was the case, that it wouldn't be, that's not going to help anyone simply by putting in the fee waiver application.
I think maybe we need a bit more information to answer that question.
So someone's put up about de facto adoption. Child's appeal was allowed on Article 8 and was made finding that rules were not made, and now has been granted limited leave 2.5 years, pay the IHS. Should he not get indefinite leave to enter? De facto adoption, the rules were not met.
I think that must be met rather than made.
Yeah. That would still fall if it's a de facto adoption and the appeals being allowed on Article 8 grounds. It depends whether it was with reference to the immigration rules. But I think there certainly is a case for making an application for indefinite leave to remain.
Well, if the rules for a de facto adoption are not met, I don't see how you could get indefinite leave. I mean, it would be a matter of discretion, wouldn't it?
Yeah.
But if, let's say, the adoptive parents hadn't been living outside the UK for long enough, or hadn't been living, or one of them hadn't been living with the child for long enough, then you wouldn't meet the requirements of the rule for de facto adoption. But it could nevertheless be a breach of Article 8 for the child not to be admitted to the UK to live with the adoptive parents. They could then perhaps make an application for the child to be adopted in the United Kingdom. So it would be a UK adoption rather than a de facto adoption from abroad during the 2.5 years that the limited leave will go on for.
So someone else has asked a question, Mohammed Rahman.
Yep.
Saying a low-earning couple living in a one-bedroom council accommodation wanting to adopt a child from different countries, can they do, and what will the process be?
I can chip in on this one because I'm doing some work on something similar at the moment. But in order to adopt a child from overseas, you have to go through your local authority. So there are no lower standards for adopting from overseas than there are for the UK. And the purpose of that is that children who are being adopted are vulnerable. They lose ties to their birth family, no matter how serious those circumstances which cause them to need to become adopted people. That is going to have a lifelong impact on them. And that it would be quite wrong for there to be a lower threshold or a lower standard of life for children adopted from overseas. So there is, however, a difference between they just want to adopt and they think it would be nice to adopt a child from overseas, or they have a family member who is in need of what would essentially be a special guardian. There's nobody else to do it. They've been asked, can you please have this child? The alternative is that the child goes into state care in their country of origin. Better to be adopted by a family member here. So there are different considerations, but you do definitely have to be assessed as suitable to adopt by the local authority. The alternative method through it is, as we've just been talking about, de facto adoption, in which the couple in the UK would need to go and live with the child abroad, and take on that de facto adoptive role for them. And I think the last time I checked, it was for either 18 months or 2 years. I don't know whether that's still the case, but it's a significant period of time. You can't pop over for a 2-week holiday and then say, this is my de facto adopted child. You have to have lived with them in their country of origin for some considerable time.
Yes. Yes, I think sorry to interrupt. I think the adoptive parents must be abroad for 18 months, but one of them living with the child for at least 1 year.
Yes.
Anyway, it's still a long time.
Yes, it's still a long time.
Yeah.
So if it is the case that they know they wouldn't be considered suitable and they want to de facto adopt a family member's child, they need to go and live with the child abroad. If it is that they want to do it through the rules, which is obviously the easier, preferable route, then they need to begin making inquiries with their local authority. Being low earners is not a bar to being an adoptive parent. Being in a 1-bedroom council accommodation, the council accommodation, no bar to becoming an adoptive parent. 1 bed might be. Depends on the age of the child they're adopting and whether we're talking about a 1-bedroom flat which has a separate bedroom, or whether it's sort of a studio in which the bed and the kitchen are right sort of on top of each other. If their accommodation isn't assessed as suitable and they still wish to adopt, they can approach the local authority for support in getting that accommodation sorted. But it is the local authority that's the first place to start. And from there, they can then apply to meet the immigration rules to bring in the child through the proper mechanisms.
Can I just add, Julian, if the child is actually related to the couple, they can use paragraph 297, exclusion undesirable, because of oh gosh, what's the wording?
Serious and
Something compelling
family, serious and compelling
compassionate family or other reasons. So if you're related, even quite remotely, I think, to the child, you don't have to adopt the child. It can come into the UK with indefinite leave to enter. Of course, if you then want to adopt it properly so that it becomes your child, you can still do that. But once the child is here anyway with indefinite leave to enter. But you still have to show that there are compelling family, serious and compelling family or other considerations that make exclusion of the child undesirable.
A good case on that to go to is Mundaba, MUNDBA, which actually covers, because there's no other case law with reference to that one. But yeah, I would say that I've had a few cases where I've had to use, or 2971F has been used, but the courts will always be cautious. The Home Office will be cautious, of course, looking at young children in relation to safeguarding concerns. So there's always going to be that element as well, best interests of the child as well. But it's a good route.
Yes. Oh, now I should relay a message which I got a few minutes ago, actually, from our sponsor, Wasanta, and he asked if Samina could cover Sarah's talk at least for 20 minutes. So despite what I said about carrying on with the question and answer session, would you be able to
I can,
give a brief
I'll do a
run
whistle
through of
stop.
Sarah's
Okay.
talk?
Yeah. And before we go, though, I do want to say I can see there's something from C Record who is saying that the Home Office deem fee waiver applications do extend leave to remain. And I've looked it up and I think that's right. That it extends. I was so sure there was something that didn't allow them to be, it didn't allow the fee waiver to be an extension, but they now, I don't know whether it's been included now or it's always been there, but under Section 3C, leave a fee waiver application, as long as it's made 28 days or less before your leave expires, then it does extend
Ah,
leave. So thank you, good catch there.
yes, very useful to know.
Yeah.
Ah, okay. Well, I think time's getting on, isn't it? It's getting on for 4 o'clock.
Okay.
So maybe we should would you like a little break first, Samina, before starting?
No, I think I'll go straight in and then we can finish earlier if that's okay.
Yeah, probably people would like to get away earlier rather than later. Okay. So we'll perhaps before we hear from Samina about Sarah's own talk, Sarah Pinder, like Samina, has been appointed a full-time judge of the First Tier Tribunal and
Upper
the
Tribunal.
deputy of the Upper Tribunal. And so she also should be congratulated, and she should also be thanked for her very valuable contributions over many years to these webinars and previously seminars. Unfortunately, like Samina, she won't be able to come in future because now being a full-time judge, she can no longer do it. But anyway, that's enough from me. So over to you, Samina. Thank you.
Thank you. So sorry, it was just that she, just to share that it was the Upper Tribunal she's been appointed to as on a full-time basis.
Oh,
Yeah.
sorry, the Upper Tribunal. Oh, wow. Good for her.
And she's really sorry that she can't be here, and she's actually has expressed the same in terms of attending these webinars for a number of years. I think she was right at the outset working with Wasanta and introduced us all to Wasanta and AstenJ. So she's really sorry that she can't be here for that last one. She may join us at some point. So yeah, we'll see. But let me come to her slides then. And she was going to cover, as I say, this is going to be a whistle-stop tour, not only withstanding that I have a slight cold and it's getting worse, but also because I'm covering for Sarah. But she was covering the work visa route changes and the new immigration salary list. Now, they were made, let's see if I can get to the next slide. Here we go. So these new changes, there were two sets of changes. There was one on I'm just trying to find the dates. These are the ones on the 14th of March, which applied after the 4th of April. But there was a whole load of other changes which were around the time of, they were all announced on the 4th of December 2023, and those ones came into force. They started, different ones came into force on the 19th of February through to, as I say, the 14th of March. The purpose of the changes with reference to these is what the Home Secretary at that time described as a 5-point plan to reduce immigration. And the changes, as I say, came into force in accordance with two sets of revisions. The ones we're looking at now are these, and the main focus is with reference to the salary thresholds for sponsoring skilled workers. The UKVI introduced new general salary thresholds for the shortage occupation list was replaced with the immigration salary list. You can see the link is added here. It's an interactive link, so you can get through to that salary list. And the SOC 2010 occupation codes were replaced by the SOC 2020 occupation codes. And we've heard a lot already about the SOC codes during the course of our Q&As today. So that's something worth keeping in mind with reference to the general salary thresholds, and when looking at the different jobs on the shortage occupation list. Just taking you to the research briefing House of Commons published paper, just to take a look at why some of these changes came about. And I've already said the Home Secretary at the time introduced this 5-point plan, but he stated that it was because the net migration numbers were believed to be too high, estimated, as you can see the statistics there, at 764,000 in 2022, with international students, social care workers, and immediate family members and dependents as the main contributors to the increase, along with some of the humanitarian visa schemes that we've seen and people claiming asylum. It's, well, I won't say any more about that, but it's interesting to see whether that there are changes to what we have seen at present time, especially given individuals' Article 8 rights, family life, and so on. With reference to workers coming to the United Kingdom, it's always been the case that they could bring family members, and this seems to be quite restrictive in terms of family being able to join workers here in the United Kingdom, which in turn may have a knock-on effect on those who might be applying to come in some of these categories of individuals. The changes were announced in December, and they followed the what we saw were the restrictions in relation to student leave and student dependence, which were announced in May 2023, and they've been in force since 2024. And you can see that the Home Office says that 300,000 of those people who moved to the UK last year would not have been able to come had all the changes been in place. So they, by way of their statistics, have attempted to demonstrate their changes will make a difference. But as I see going forward, it's going to be interesting to see whether or not these changes do stay as they are, or if the Article 8 and the individual's human rights trump the changes brought about with reference to any challenges made to the rules or changes to the rules themselves. Right, so the thresholds, there's previously with skilled workers, skilled worker route, the threshold was 26,200 per annum. It's now increased to 38,700, which is known as the floor salary. You then have to show that you are paying or being paid an hourly minimum rate of 15.88 per hour, which is quite a steep rise from the 10.75 that was which was previously which an individual previously would have to demonstrate. I'm just looking at, yes, so the SOC 2020 occupation code, the standard occupational classification, you'd have to demonstrate the salary under that relevant occupation code. So you'll have to cross-refer back to that. And looking at the provisions for new entrants, I'm just going to check that I've got this right. The relevant general salary has been increased from 20,960 to 30,960 with a minimum hourly rate of £11.90 per hour. So there's a concession here of a 70% reduction to the salary under the occupation code, which also remains. But generally, to calculate the minimum salary applicable for someone applying as a skilled worker after the 4th of April 2024, you look at the general salary of 30,960, 70% of the salary under the relevant SOC 2020 occupation code, and an hourly of £11.90. Now, there is a similar provision for PhD holders, which is unaffected, and a reduction of 10% to the salary will apply to those who hold a PhD in a subject relevant to the job, and a reduction of 20%. And I think that might be on my next slide. It is actually on my next slide. 20% for those who hold a PhD in a relevant STEM subject to their role. Now, a lot of you would have been hopefully here in previous other talks in February and last year in October, where we've extensively covered skilled workers. So cross-refer back to those slides in terms of looking at, when you're looking at these occupations, the relevant or the various occupations as skilled workers, when you're looking at these changes relevant to those, that talk that we've given previously on skilled workers. I'm just going to see whether I can go to the, what I did want to say, yeah, there are different salaries also for NHS staff and education workers, and that's based on our national pay scales. So there are special cases. Social care workers are also special cases, because I think we all know that there is a shortage, a specific shortage in these categories of individual, these categories of jobs. So certainly they have been provided for, and you can see that reflected by the income or salary threshold of 23,200 for these particular category of individuals. So it's worth cross-checking for these individuals whether or not, or what might apply to them insofar as the salary threshold is concerned. I've already highlighted that the immigration salary list replaces the shortage occupation list, which is now redundant. In total, there's going to be 23 occupation codes under the new list. All roles that come under the code on this list will benefit from a general salary of 30,960 and a 20% reduction of the salary from the SOC 2020 list of codes. So again, you'll need to consider whether or not you fall to be considered, or the applicant who's come to you falls to be considered with reference to any kind of discount or reduction in that general salary threshold. So the minimum, just to summarize, the minimum salary when sponsoring on or after the 4th of April 2024 under a code that appears on the immigration salary list must meet both the general salary of 30,960 and 80% of the salary under the relevant SOC 2020 occupation code. You can see that this list is going to be an interim one. It will be re-examined later this year. So you need to, at all times, keep up to date with what the salary thresholds are by virtue or by reference to the list. And I think we've got, I'm just going back in the slides. Yes, there is. That's the interactive one that I talked about, the salary list there. There are transitional arrangements in place for those who've probably already been granted or sponsored before the 4th of April 2024. So as long as they have costs which has been issued to them before the 3rd of April 2024, then they're going to be able to rely on the costs and the immigration rules in place or in force at that time. And the same works for any kind of extension applications that they might make. So, or changes of employment. So, as long as the entry clearance was granted before that date, then they will continue to look at the reduced salary. And the new general salary for the applicants will be 29,000, but they would have to also meet the, and that's raised from the 23,000, and they would also have to meet the 70% reduction of the relevant COS 2020 code. I've already highlighted the PhD concession will apply for those with PhDs. And the hourly rate will be applicable to those who sponsored before the 4th of April 2024 will increase to £11.90. Let me just check on the next code. Yeah, so there again, that's exactly what I was saying. The PhD concession will apply. That's the second bullet point, with a 10% reduction for a relevant PhD and a 20% reduction for a STEM PhD. And you can see that the general salaries are 26,100 and 23,200. Looking at new entrants, for those who've been issued before 4th of April, and that's the first bullet point, the concession will continue to apply to them. But as I said, the general salary will raise, and 70% reduction of the relevant SOC 2020 code. This hopefully has a bearing on those who apply or who are regularly making applications in the skilled worker for individuals who are skilled workers. And it's very what can I say, it's very almost a tick box in being able to demonstrate these amounts. So cut-off date here is the 4th of April 2024, and it's being able to show if you were granted leave before then the lower amounts apply. But if it's after, then there's been an increase, and you have to demonstrate those amounts. I was just going to look at, for those with codes that are on the immigration salary list, there's a minimum salary. I think I have covered that. So there's a minimum salary, I covered that quite early on, of 23,200 that will apply with the 80% reduction of the salary under the SOC 2020. And then the hourly rate that's applicable will increase to £11.90. But just looking at anyone who's had leave before the 4th of April 2024, any extension applications that are going to be made by them in these categories, certainly looking at the calculations, are going to have to be made before the 4th of April 2030. So I think that's how it's going to work. I'm just looking to see if I can find anything more on the calculations in relation to that. And then health and care workers, they are their occupation code is 10 under the SOC 2020, who will qualify for health and care worker visas, and that for any roles that they meet for all of the criteria of health and care worker visas, a general salary of 23,200 and a minimum hourly rate of 11.90 is going to apply for them. So that stays quite stable in relation to the healthcare worker visa. I'm just going to go back because I wanted to just check. There we go. Yeah, which, social care workers and so on would fall within the healthcare worker visa category. And, oops, sorry. just looking in conclusion to the proposed changes of the skilled worker route which were unveiled, it does mark a significant change to the landscape, as I said, with reference to family life particularly, but also raising the salary thresholds. And I think I also covered the minimum income rule for spouses in the United Kingdom on my previous talk, but also on this talk. And we saw that there's been a raise from 18,600 upwards. And one of the reasons behind the salary thresholds here, what they attempted to do was bring them in line with the minimum income rule, in line with the thresholds or the rise to thresholds that are seen in worker categories. But it's potentially a new era of requirements and considerations for both employers and prospective employees. And the government would say that these changes, the government at the time, they would say that the changes reflected a concerted effort to modernize and refine the UK skilled worker route, aligning it with the evolving economic and societal needs, you know, the what we've seen reflected around the globe. But there are going to be many difficulties, one would envisage, for UK employers in many sectors, and being able to meet these thresholds perhaps, and recruit those who are needed in these sectors. So I suppose it's, again, given the change of regime, it's going to be interesting to see what happens with reference to some of these salary thresholds, and how and whether there are any concessions ongoing in the future with reference to individuals who might not be able to meet those, or even a shift in relation to family being able to bring family over. But that does bring me, and as I said, it was a whistle stop. Sarah's slides did cover exactly what she was going to say in detail, so it's there, set out. I can't add anything further to that insofar as the changes are concerned, but I'm happy if you have any questions in relation to the skilled worker route or those changes that are going to be made, then you pop those questions in the Q&A. Right, there aren't, but I can see that there's some more questions. Richard, I don't know if you're around, but there is another question from Mahinda about the last, about one of the previous questions asked, with reference to the marriage application. And I'm just going to check in, but it's, although the marriage application is a human rights claim, as a student is not required to leave the UK, Section 113 defines human rights claims as made in person, that to remove him or to require him to leave the UK, the student is not currently subject to removal nor required to leave, as he still has leave to remain as a student. And again, this is not an entry clearance application either. So it's an in-country application. So, and I'm confused as to, I think I probably need to go back, Mahinda, to the original question, which I now can't find. This is if the student makes an in-country marriage application before the student visa is due to expire. And if that marriage application is refused while he's still within the validity of his student visa, will this attract a right of appeal? His student visa is not curtailed. There is a right of appeal guidance, and I think that would be really helpful to work out if they had a right of appeal. So I think you can go back to that and look at that if you want to, Mahinda. I think you might be right insofar as it being a human rights claim. So it's worth looking at the rights of appeal guidance, the UKVI guidance if you already haven't, and that will guide you as to whether there will be a right of appeal. I think they may well be. But Iqma's set out a question there, which is, let's say a skilled worker brings their dependent family members into the UK after the skilled worker has already entered. Once that skilled worker completes 5 years in the UK and applies for ILR, can the dependent family members who have not yet completed 5 years in the UK apply for ILR at the same time? If not, do the dependent family members have to switch onto the FRM route, and would the 5-year clock start again upon switching? That's really interesting. I have a feeling if they got indefinite leave to remain under the 5-year route, there is, again, I'm great at looking at policies, and there is an indefinite leave to remain policy with reference to tier point-based system cases. So I think it's worth looking at that. There are a few, I have had a case like this, and I'm trying to recall exactly what happened there, but I think because they don't have 5 years themselves, they would not be granted ILR. They may well be granted, if I'm not mistaken, leave, an extension of leave, which takes them up to the 5 years. And then after that, they would be eligible to apply for the ILR. So I don't think that it's necessarily, I don't know what form they would have to use, but I'd go back to the ILR guidance for point-based system cases. But yeah, that's an interesting one. So not a straightforward answer, but I think they may well get that extension. Okay, I've got a question from Gunjan. Thank you, Gunjan. One of my clients has grandparents who have British passports, and she's on a skilled worker route. Can she switch to any visa based on her grandparents being British? Ooh, that's a mixture of nationality and worker visa. I don't know. Is the question. I don't think so is the answer. You're talking about two very different things. They may have to look into nationality, and you may need an advice on nationality about what her rights, because her grandparents have British passports, might be. It depends what country she's from. So there's lots of different elements there. And if you take a full history of her background, it may well be that somewhere there, depending on how her grandparents have British citizenship, that she's entitled to citizenship as well. But it's a very complex area, citizenship. So it's worth exploring that further, Gunjan. And then I've got anonymous attendee. Will family members of skilled workers find it easier getting visitors visas now that they can't join their family members? One is going to have to hope so. I mean, it's certainly a factor, isn't it? And I think there will be more vigilance about the intention to return at the end of that visa period. So it's worth front loading. I always say this, I think all of us will say this, that front load an application, because it's always worth doing that and saying, well, we do intend to return. It's because we're not allowed to come in on any other route. We want to visit our family and return back. And I don't see what the harm is in that if you front load it, because they are restricted from entering and joining their family on a permanent or a on the basis that they are skilled workers. So that's worth doing. Okay. All right, brilliant. Thank you. And I think I've seen a message from AstenJ which says, thank you to everyone. And I think that brings us to an end of today's program. I'll wait for Richard, one of our AstenJ.
Sorry, I just have to unmute.
Yeah.
And I've been asked to start my video. Sorry about that. Here we go. Well, you finally, oh, wonder what, it's better. I'm blinded by the light there. So thank you very much for stepping in and doing that whistle-stop tour of Sarah's talk. And you've really been a very stalwart supporter of AstenJ right up to the end, Samina. So thank you very much. I think you've done enough for one day and more than enough. And thanks very much also to Julian, who I think will also be one of our regulars. Well, she's become a regular already, and hopefully that will continue long into the future. So we bid a final farewell to Samina and do convey our sincere thanks to Sarah as well. And thank you, everybody, if you're still with us, for staying on so long. And we hope that you found the webinar today useful. And thanks also to Wasanta, Ajanta, and Tarindu, who've been running the show. And apologize for my ineptitude with the slideshow earlier on. I'm a bit of a digital dinosaur, obviously. But we'll see you hopefully at the next webinar. So goodbye now, everybody. Goodbye.